Next, page, Chapter 7, Limitation of Rights. 7.1 The General Limitations Section, Section 36, A. Introduction. The nature of a general limitation provision. Section 36 provides a framework for limiting constitutional rights. Ensures limitations are justifiable in an open and democratic society. Prevents arbitrary restrictions on rights. B. The two-stage approach. 1. Stage 1. Establishing the infringement determines whether a right in the Bill of Rights has been violated. 2. Stage 2. Justification of the limitation assesses whether the limitation is reasonable and justifiable under Section 36(1). 7.2 Criteria justifying the limitation of rights. A. Law of general application. A limitation must be based on a law of general application to ensure fairness and consistency. I. Authorized by law must be found in legislation, common law, or customary law. 2. General application. The law must apply equally and not be arbitrary or discriminatory. 3. Administrative action. Decisions made by administrative bodies must comply with the principles of legality. B. Reasonableness and justifiability. In an open and democratic society based on human dignity, equality, and freedom, proportionality test determines whether a limitation is justified. I. Proportionality balances the right being limited against the importance of the limitation's purpose. 2. Section 36(1)(a). The nature of the right. Some rights, for example, human dignity, life, are harder to limit than others. 3. Section 36(1)(b). The importance of the purpose of the limitation. The reason for limiting the right must be substantial and legitimate. 4. Section 36(1)(c). The nature and extent of the limitation. The degree to which a right is restricted is relevant to justification. V. Section 36(1)(d). The relation between the limitation and its purpose. There must be a rational connection between the limitation and its intended outcome. By Section 36(1)(e). Less restrictive means to achieve the purpose. If a less restrictive way exists to achieve the goal, the limitation may not be justified. C. The Section 36(1) inquiry in a nutshell. Step 1. Identify whether a right is infringed. Step 2. Determine if the limitation meets Section 36(1) criteria. Step 3. If the limitation fails the test, it is unconstitutional. 7.3 Limitation of rights by other provisions of the Constitution. Certain constitutional provisions allow for automatic or explicit limitations of rights. Examples: state of emergency provisions, specific constitutional exclusions from certain rights. 7.4 Demarcations of rights and special limitation clauses. Some rights contain built-in limitations. Example: freedom of expression excludes hate speech, incitement to violence. Special limitation clauses provide specific criteria beyond Section 36. Next page. 7.1 The General Limitations Section, Section 36. A. Introduction. The nature of a general limitation provision. Constitutional rights are not absolute, they are subject to boundaries set by rights of others, public order, safety, and health. Democratic values. Section 36 of the South African Constitution outlines criteria for justifiable restrictions on rights. Section 36, Limitation of rights. Rights in the Bill of Rights may only be limited if the limitation is based on a law of general application. The limitation is reasonable and justifiable in an open and democratic society. Relevant factors include: A. Nature of the right. B. Importance of the purpose of the limitation. C. Nature and extent of the limitation. D. Relation between limitation and purpose. E. Availability of less restrictive means. No law may limit a Bill of Rights provision unless permitted by Section 36 or another constitutional provision. Key points. Limitation equals infringement, or justifiable infringement. A law infringing a right is not necessarily unconstitutional if the infringement meets Section 36 criteria. The limitation is justified in a democratic society. Rights cannot be limited arbitrarily. Justifications for limiting rights must be exceptionally strong and serve a compellingly important purpose. Even if the purpose is valid, a limitation must be effective in achieving its goal. Implemented in a manner minimizing rights infringement. B. The two-stage approach. Section 36 applies generally to all rights in the Bill of Rights. Differs from United States Constitution, no limitation clause. German Bill of Rights, specific limitation clauses. Canadian Charter of Rights and Freedoms, general limitation clause, similar to South Africa. Two-stage test. 1. Stage 1. Identifying an infringement. Court determines whether a right has been infringed. Burden of proof is on the applicant. 2. Stage 2. Justifying the limitation. If an infringement exists, the respondent, usually the state, must prove justifiability under Section 36. Courts may assess justifiability even if the state does not provide a defense. For example, National Coalition for Gay and Lesbian Equality v. Minister of Justice. Key considerations. Interpretation versus justification. Interpretation defines the scope of the right. Justification assesses whether an infringement is reasonable and justifiable. Factual inquiry. Justification often requires evidence, for example, sociological or statistical data. Respondent must provide material evidence supporting the limitation. If no evidence is provided, the court may rule the limitation unjustifiable. Constitutional Court Rule 30, 1998. Allows factual evidence if it is common cause or incontrovertible. It is official, scientific, technical, or statistical and easily verifiable. Next page. Study notes. Limitation of rights. Section 36 7.1, the General Limitation Section, Section 36A, Introduction, the nature of a general limitation provision. Constitutional rights are not absolute, they are limited by rights of others, public interest, order, safety, health, democratic values. Section 36 provides criteria for justifying rights limitations. Text of Section 36. Rights may only be limited by a law of general application if reasonable and justifiable in an open, democratic society. Considerations include 1. Nature of the right. 2. Importance of the limitation's purpose. 3. Nature and extent of the limitation. 4. Relation between limitation and purpose. 5. Availability of less restrictive means. Key points on limitation. Limitation justifiable infringement. Not all infringements are unconstitutional, only those failing Section 36 justification. Strong reasons are required, balancing public interest versus individual rights. The limitation must effectively serve its purpose and must be the least restrictive option. B. The two-stage approach. 1. Stage 1. Has a right been infringed? Interpretation-based, determining the scope of the right. Burden is on the applicant to prove infringement. 2. Stage 2. Is the infringement justifiable under Section 36? Respondent must justify the limitation under Section 36 criteria. Even if the respondent does not defend the law, the court must analyze justification. National Coalition for Gay and Lesbian Equality v. Minister of Justice. Courts may undertake only cursory analysis if the state presents a weak defense or agrees with unconstitutionality. Evidence-based process. Justifiability often requires sociological, statistical, or policy-based evidence. Failure to provide justification may lead to unconstitutionality. Rule 30 of Constitutional Court's 1998 rules allows relevant factual evidence. 7.2 Criteria justifying the limitation of rights. A limitation is valid if 1. It is a law of general application. 2. It is reasonable and justifiable in an open and democratic society. A. Law of general application. I. Authorized by law. Only laws can limit rights, not policies or practices. Rule of law principle. Government power must be derived from the law. If an action lacks legal authority, it is unjustifiable. August v. Electoral Commission, denying prisoners voting rights was not authorized by law. What qualifies as law? Legislation, original and delegated, common law, including public and private law, customary law. Exclusions, policies, practices, and contractual provisions do not qualify. Courts can develop legal limitations through common law. 2. General application. Formal requirements. The law must be clear, accessible, and precise so individuals can know their rights. Substantive requirements. The law must be impersonal, equal, and non-arbitrary. Ackerman J. Arbitrary laws violate the rule of law by causing unequal treatment. Key cases. S. V. McQuanian. The death penalty law was challenged for not applying uniformly across South Africa. Court ruling. Differences in regional application did not make it fail the general application test. Next page. 7.2 Criteria justifying the limitation of rights. A law may limit a right in the Bill of Rights if it meets two criteria. It is a law of general application. It is reasonable and justifiable in a democratic society based on human dignity, equality, and freedom. Underscore. A. Law of general application. I. Authorized by law. Only a law of general application can limit rights. The rule of law requires government actions to be lawful, otherwise, it would be despotism or tyranny. Case law, August v. Electoral Commission. The Independent Electoral Commission failed to allow prisoners to vote in 1999. Since this action was not authorized by any law, it could not justify limiting rights under S-36. What qualifies as a law of general application? Legislation, original and delegated. Common law, private and public, including criminal law. Customary law. Exclusions. Policy or practice, even if from a state organ. Contractual provisions. Uncodified parliamentary privilege. Courts can develop limitations via their common law powers. Underscore. 2. General application. Law must be clear, accessible, and precise for affected individuals to understand their rights and obligations. It must be impersonal, equal for all, and non-arbitrary. Case law, S. v. McWanian. The death penalty was abolished in Ciskei but not elsewhere in South Africa. The court ruled that regional legal disparities do not mean a law lacks general application. Case law, President of the Republic of South Africa v. Hugo. A presidential act released mothers of children under 12 from prison. The majority ruled this did not violate equality. Mukgoro J's dissent cited European and Canadian law stating that a law must be accessible and precise. Held that executive rulemaking, presidential acts, can qualify as law. Distinguished it from delegated legislation, arguing it still derives legitimacy from the Constitution. Kriegler J's dissent argued the act was not a law, but an executive order directed at specific officials. Since it applied only once and only to a specific group, it lacked general application. Key takeaways on law of general application. 1. Broad definition of law. Includes legislation, delegated legislation, common law, and certain executive rules. Does not require formal publication in the Government Gazette. 2. Substantive requirements. Must be accessible, precise, and generally applicable. Must not target specific individuals. Underscore. Case law, DeLeo v. Speaker of the National Assembly. A member of Parliament was suspended by an ad hoc committee. The High Court ruled the suspension was not justifiable under the limitation clause. No statutory or constitutional authority allowed such an action. Parliamentary privilege does not qualify as law of general application since it is uncodified and unpredictable. It applies unequally. It lacks precedent and parity of treatment. Underscore. Conclusion. The law of general application must be lawful, accessible, and precise. Apply equally and impersonally. Not be arbitrary. Executive actions can sometimes qualify as law, but not if they target specific individuals. The courts play a key role in determining whether laws meet these criteria. Next. Page 3. Administrative action as law of general application. Distinction. While delegated legislation qualifies as a law of general application, administrative action taken under such legislation does not. However, the legislature can delegate discretionary power to administrators, allowing them to limit rights within legal constraints. If a law grants wide, unconstrained discretion to an administrator to limit rights without clear guidelines, it does not qualify as a law of general application. Underscore. Case law, Dawood v. Minister of Home Affairs. Issue, the Aliens Control Act 96 of 1991, S25 9b. Allowed certain foreign family members of South African citizens to stay in the country pending their immigration permit applications, but required others to leave. The effect of S25-9 read with S26-3 and 6. Immigration officials had discretionary power to refuse or extend temporary residence permits. If a foreign spouse was refused a permit, the South African spouse had to choose between leaving SA or being separated. The right to cohabit, central to marriage and dignity, was limited by this discretion. Underscore. Could a limitation be justified? No. The provisions failed to qualify as a law of general application because unconstrained discretion was given to officials. The law was not clear or accessible, violating rule of law principles. People did not know what factors were relevant in decision-making. There was no explicit requirement that officials consider constitutional rights. If rights can be infringed without legal redress, the purpose of the Constitution is undermined. Underscore. Key takeaways on administrative action and general application. 1. Delegated discretion must be limited by legal guidelines. 2. Broad, unrestricted discretion does not create a law of general application. 3. Legislation must explicitly state when and how a right may be limited. 4. Unclear laws risk unconstitutional application and undermine the rule of law. 5. Legislation must not simply delegate constitutional decisions to administrators without guidance. Next page. B. Reasonableness and justifiability in an open and democratic society based on human dignity, equality, and freedom. A law restricting a fundamental right must do so for acceptable reasons in an open and democratic society. The limitation must be reasonable, meaning it should not invade rights more than necessary to achieve its purpose. The limitation test requires: the law serves a constitutionally acceptable purpose. Proportionality between the harm done, rights infringement, and benefits achieved, law's purpose. I. Proportionality. Established in S.B. McQuanian. Limiting constitutional rights requires balancing competing values. No absolute standard for reasonableness, each case is assessed individually. The test considers nature and importance of the right being limited, purpose of the limitation and its importance to democracy, extent of the limitation and its effectiveness, whether the goal could be achieved through less restrictive means. Courts must defer to the legislature on policy decisions, rather than second-guess them. Summarized in S.B. Buawana. Courts weigh the purpose, effects, and importance of the infringing law against the nature and impact of the infringement. Greater infringement equals stronger justification needed. Proportionality analysis under S36 of the 1996 Constitution. The test includes the following 5 factors. 1. Nature of the right. 2. Importance of the limitation's purpose. 3. Nature and extent of the limitation. 4. Relation between the limitation and its purpose. 5. Existence of less restrictive means to achieve the purpose. Key points from McQuanian. Limitation tests are not rigid, they adapt based on context. Courts must assess each case separately. Courts must balance rights against justifications rather than follow a strict formula. 2. Section 36(1)(a), the nature of the right. Proportionality requires weighing the harm, rights infringement, the benefits, law's intended purpose. Some rights carry more weight than others. Stronger rights require stronger justifications for limitation. A court assesses a right's importance in the constitutional framework. Example, S.V. McQuanian, death penalty case. The case examined the constitutionality of the death penalty. The court held that it infringed 3 fundamental rights. 1. Right to life. 2. Right to human dignity. 3. Freedom from cruel, inhuman, or degrading punishment. To be constitutional, the death penalty had to qualify as a justifiable limitation of these rights. Balancing test. Purpose of the death penalty versus violation of rights. Court assessed the importance of the 3 rights. Right to life and dignity equals most fundamental. State must prioritize these rights in all its actions, including punishment. Freedom from cruel punishment is an extension of human dignity. Conclusion. Given the importance of human dignity, very strong justifications would be needed to limit these rights. The death penalty failed this justification test. Key takeaways on reasonableness and justifiability. 1. A law must serve a legitimate purpose and not infringe more than necessary. 2. Proportionality determines if the limitation is justifiable. 3. More fundamental rights require stronger justification for limitation. 4. Courts assess limitations on a case-by-case basis. 5. S.V. McQuanian established that right to life and dignity are paramount. The state must uphold these rights, even in criminal punishment. If a limitation is unjustifiable, the law will be struck down. Next page. Reasonableness and justifiability in an open and democratic society. A law restricting fundamental rights must be acceptable in an open and democratic society based on human dignity, equality, and freedom. The law must be reasonable, meaning it should not infringe on rights beyond what is necessary to achieve its purpose. Limitation test. The law must serve a constitutionally acceptable purpose. There must be proportionality between harm caused, rights infringement, and the benefits achieved. Proportionality. S.B. McQuanian and the proportionality test. Constitutional court's approach, limiting rights in a democracy, requires balancing competing values, assessed through proportionality. No fixed standard for reasonableness and necessity, assess case by case. Balancing process. Nature of the right being limited. Importance of the limitation's purpose in a democratic society. Extent of the limitation and its effectiveness. Whether the purpose can be achieved by less restrictive means. Deference to legislature. Courts acknowledge policy decisions by legislators but still assess reasonableness. Underscore. Section 36 Proportionality Factors. 1. Section 36(1)(a), the nature of the right. Rights have different levels of importance, some weigh more heavily than others. More fundamental rights require stronger justifications for limitation. S.V. McQuanian example. Death penalty violated the right to life, dignity, and freedom from cruel punishment. Rights to life and dignity are the foundation of human rights and democracy. Limiting such rights requires compelling justification. 2. Section 36(1)(b), the importance of the purpose of the limitation. Reasonableness requires that the limitation serves a purpose. Justifiability requires that purpose to be worthwhile and important in a constitutional democracy. S.V. McQuanian example. The state justified the death penalty based on 1. Deterrence of violent crime. 2. Prevention of repeat offenses. 3. Retribution. Court found the first two purposes legitimate, but rejected retribution as inconsistent with a society based on reconciliation and Ubuntu. Legitimate purposes recognized by the Constitutional Court. 1. Administration of justice, for example, protecting witnesses, enforcing court orders. 2. Crime prevention and prosecution. 3. Reducing unemployment. 4. Regulating health and welfare. 5. Protecting the rights of others. 6. Fulfilling constitutional obligations. 7. Healing past divisions. 8. Complying with international obligations. 9. Preventing illegal immigration. 3. Section 36(1)(c), the nature and extent of the limitation. The limitation should not go further than necessary to achieve its purpose. S.V. McQuanian example. The death penalty caused severe, irreparable harm to fundamental rights. It is irrevocable, rejects rehabilitation, and denies human dignity. The court ruled that the harm caused outweighed the benefits, making it unjustifiable. Underscore. These principles guide the proportionality inquiry to determine whether a right's limitation is reasonable and justifiable in a democratic society based on dignity, equality, and freedom. Next page. Section 36(1)(d), the relationship between the limitation and its purpose. A law that limits rights must be reasonable and justifiable by serving a legitimate purpose. There must be a proportional relationship between the harm caused by the right's infringement, the benefits achieved by the law. Causal connection requirement. The law must actually serve its intended purpose. If it does not or only marginally contributes, it cannot justify infringing on fundamental rights. S.V. McQuanian example. States justification. The death penalty serves deterrence and prevention of recurrence of violent crime. Court's analysis. Prevention of recurrence, strong causal link, an executed criminal cannot reoffend. Deterrence. The state failed to provide conclusive evidence that the death penalty reduces violent crime. Didcot's view, the burden is on the proponents of capital punishment to prove deterrence. The mere possibility of some benefit is insufficient when human lives are at stake. Conclusion. The death penalty was not shown to be more effective than alternative punishments. Lack of clear evidence of deterrence weakened the justification for the limitation. Underscore. Section 36(1)(e), less restrictive means to achieve the purpose. A limitation of rights must be proportional to its benefits. If less restrictive means can achieve the same purpose without infringing rights to the same extent, they must be preferred. Courts allow the state some policy discretion, but the limitation must not be broader than necessary. S.V. McQuanian example. Death penalty's purpose. Deterrence and prevention of recurrence. Less restrictive alternative. Life imprisonment also prevents repeat offenses. Long-term imprisonment can serve as an alternative deterrent. Proportionality test. The death penalty imposes irreparable harm on the right to life and dignity. No conclusive evidence that it is a better deterrent than life imprisonment. Life imprisonment should be preferred as it is less restrictive. Underscore. Overbreadth and narrow tailoring. A law that limits rights more than necessary is overbroad. Courts require laws to be narrowly tailored to achieve their purpose without excessive restrictions. Examples of overbroad laws. Liquor consumption regulations. A law prohibiting improperly clothed performers in liquor-serving venues affected legitimate theater performances, not just striptease bars. Drug prohibition. A blanket ban on DAGA affected Rastafarians' religious freedom, which could have been addressed with an exemption. Military speech restriction. A rule banning all public protests by Defense Force personnel was too broad, limiting legitimate free speech. Conclusion. Key takeaways from Section 36(1) Proportionality Test. 1. A limitation must have a legitimate purpose. 2. There must be a clear causal connection between the law and its purpose. 3. The infringement must be proportionate to the benefit gained. 4. If a less restrictive means exists, it must be preferred. 5. Laws must not be overbroad, they should not restrict rights more than necessary. This analysis ensures that rights limitations align with the values of a constitutional democracy based on dignity, equality, and freedom. Next page. Study notes, limitation of rights under Section 36 of the Constitution. V. Section 36(1)(d), the relation between the limitation and its purpose. A law infringing a right must be reasonable and justifiable, meaning, there must be a legitimate purpose for the infringement. There must be proportionality between the harm done by the infringement and the benefit achieved. A causal connection must exist between the law and its purpose. If a law does not serve its intended purpose, it cannot be a reasonable limitation. If a law only marginally contributes to its purpose, it is not an adequate justification for limiting rights. Example, S. v. McWanian. States justification. The death penalty serves deterrence and prevention of violent crime. The Constitutional Court assessed whether the death penalty, means, achieves deterrence and prevention, ends. Findings. Death penalty ensures prevention. Criminals executed cannot commit crimes again. No evidence that the death penalty effectively deters crime. Didcot J. The burden is on proponents of capital punishment to prove deterrence. They failed to do so. By Section 36(1)(e). Less restrictive means to achieve the purpose. A limitation must be proportionate to its benefits. If a less restrictive but equally effective method exists, it must be preferred. The court allows some discretion to the state but does not blindly accept policy choices. Example, S. v. McWanian. Death penalty imposes severe costs, violates rights to life, dignity, and freedom from cruel punishment. Less restrictive alternatives exist. Life imprisonment serves both deterrence and prevention without the same degree of infringement. Conclusion. Death penalty not justifiable as a less restrictive alternative. Life imprisonment exists. Overbreadth and limitations. A law invading rights more than necessary is disproportionate, overbroad. Courts require laws to be narrowly tailored. Examples of overbreadth. Entertainment restrictions in liquor venues also ban legitimate theater performances. DAGA prohibition for all users, including Rastafarians, is overbroad if a religious use exception was feasible. Defense Force personnel restrictions on public protest are too broad and impact legitimate free speech. C. The Section 36 inquiry in a nutshell. If a law of general application infringes a right, the state must justify the limitation. Rights are not absolute but may be infringed only for a compelling reason. A compelling reason must serve a legitimate purpose in a constitutional democracy, not impose disproportionate costs compared to its benefits. A law is unjustifiable if it infringes important rights for less important benefits. It damages rights unnecessarily when alternative means exist. 7.3 Section 36(2). Limitation of rights by other constitutional provisions. Only laws that meet the Section 36(1) test can validly restrict rights. Rights may also be limited by other constitutional provisions. Example, Azapo v. President of RSA, issue, Section 27 of the Promotion of National Unity and Reconciliation Act provided amnesty for politically motivated human rights violations. Challenge, argued that it violated the right of access to courts. Court's reasoning. Interim Constitution's Postambule, National Unity and Reconciliation, explicitly permitted amnesty. Thus, the law was constitutionally valid despite infringing rights. Example, S. v. Renz. Issue, requirement for leave to appeal under the Criminal Procedure Act allegedly violated the right to appeal, S. 25(3)(h) of the Interim Constitution. State's argument, Section 102(11) of the Interim Constitution permitted leave to appeal requirements. Court's reasoning. Section 102(11) applied only to constitutional appeals, not general criminal appeals. Conclusion: the limitation was not justified. Underscore. 7.4 Demarcations of rights and special limitation clauses. Most rights in the Bill of Rights are unqualified, for example, S11, everyone has the right to life. Some rights have built-in limitations, demarcations, that define their scope. Examples of demarcations. Section 17, right to assemble only if peaceful and unarmed. Section 16(2), freedom of expression does not protect hate speech inciting harm. Section 31(2), cultural and religious rights cannot override other Bill of Rights provisions. Section 32, right to access private information only if necessary for the exercise of rights. Demarcations in rights analysis. First stage inquiry: does the applicant's conduct fall within the demarcated right? Second stage inquiry: if infringement is found, state must justify it under S36 or special limitation clauses. Special limitation clauses. Some rights have specific limitation provisions. Section 15(3) allows laws governing marriages and personal law. Section 22, second sentence, permits regulation of trade and professions. Section 23(5), 6, regulates collective bargaining in labor relations. Section 29(4), allows state subsidies for independent schools. Section 33(3)(c), just administrative action must promote efficient administration. Difference between special limitations and demarcations. Demarcations define scope of the right. Applicant must prove their case fits within the right. Special limitations justify state actions that restrict rights. State must prove justification. Underscore. Distinction between Section 36, limitations, and Section 37, derogations. Section 36 applies at all times for proportional and justifiable limitations. Section 37 applies only in a state of emergency and allows temporary suspension of rights. Even in emergencies, S36 still applies for non-derogable rights. Underscore. Key takeaways. 1. Limitations must be reasonable, justifiable, and proportionate, S36. 2. Causal connection between means and purpose is required. 3. Less restrictive means must be used if available. 4. Overbroad laws are unconstitutional. 5. Some rights contain built-in demarcations or special limitations. 6. Constitutional provisions may limit rights, but courts prefer harmony over conflict. 7. Section 37 allows derogations only in emergencies, while Section 36 applies continuously. This provides a comprehensive summary of S36 and related limitations, focusing on proportionality, alternative means, overbreadth, and special limitation provisions. Next page. Study Notes, Chapter 7 and 8. 7.3, the Section 36 Inquiry in a nutshell. Once a law of general application infringes a Bill of Rights provision, it may be justified under S36. Rights are not absolute. Limitation must serve a compellingly good reason aligned with constitutional values, human dignity, equality, freedom. The cost of limitation must not outweigh its benefits. A law should not infringe fundamental rights unnecessarily. 7.4, Section 36(2), limitation by other constitutional provisions. S36(2) affirms that only laws meeting S36(1)'s requirements may limit rights. Also allows rights to be limited by other constitutional provisions. Azapo v. President of RSA, challenged S27 of the Promotion of National Unity and Reconciliation Act for violating access to courts. Court-held amnesty provisions were justified by the postamble of the interim constitution. S.V. Renz examined whether appeal restrictions conflicted with the right to appeal. Court interpreted S-102-11 of interim constitution to apply only to constitutional matters. 7.5, demarcations of rights and special limitation clauses. Some rights are textually unqualified, for example, S11, right to life, meaning only S36 limits them. Others have demarcations that define their scope. S17, right to assembly only if peaceful and unarmed. S16(2), freedom of expression excludes hate speech. S31(2), cultural/religious rights must comply with the Bill of Rights. S32, access to private information allowed only for exercise/protection of rights. Special limitation clauses create specific conditions under which rights may be restricted. S15(3) allows laws on marriage/personal law. S22 Allows regulation of trade/professions. S23(5), 6. Permits collective bargaining laws. S29(4). Allows state subsidies for independent schools. S33(3)(c). Requires just administrative action to ensure efficient administration. Key distinction. Demarcations limit the right itself. Special limitations apply at the justification stage, with the state bearing the burden of proof. Derogation versus limitation. S37. Derogation applies only in public emergencies. S36. Applies continuously, even in emergencies. _ Chapter 8. Remedies 8.1. Constitutional remedies and Bill of Rights litigation. Application of the Bill of Rights determines whether a constitutional remedy is available. Standing defines who may seek remedies. Jurisdiction determines which courts can grant remedies. Interpretation and limitation influences how remedies are structured. 8.2. Invalidity versus remedies. A law can be declared unconstitutional, but remedies determine practical consequences. Remedies ensure effective protection and enforcement of rights. 8.3. Appropriate relief and flexibility in remedies. Courts adopt a flexible approach, tailoring remedies to the specific violation. 8.4. Purpose of constitutional remedies. Vindicate rights. Prevent future violations. Provide compensation where appropriate. 8.5. Factors influencing constitutional remedies. Nature of the right violated. Public interest. Impact on governance and law enforcement. 8.6. Constitutional remedies. A. Declarations of invalidity. I. General principles. Courts must declare unconstitutional laws invalid. S. 172(1)(a). Remedial discretion applies in crafting orders. 2. Controlling impact of invalidity. A. Severance. Courts remove unconstitutional parts of legislation while leaving valid parts intact. B. Reading in. Courts insert missing words to make legislation compliant. C. Controlling retrospective effect. Courts may limit past invalidation effects for stability. D. Suspension of invalidity. Invalidity order may be delayed to allow Parliament to fix defects. B. Declarations of rights. Courts clarify the scope of constitutional rights. C. Interdictory relief. I. Interim relief. Temporary measure to prevent ongoing violations. 2. Final interdicts. Permanent orders stopping violations. 3. Structural interdicts. Court supervises state compliance with remedy. D. Damages. I. General principles. Courts may award monetary compensation for rights violations. 2. Indirect application and new claims. Development of new categories of damages based on constitutional values. 3. Damages directly from Constitution. Compensation derived from constitutional rights rather than common law. 8.7. Other forms of relief. A. Contempt of court ensures compliance with constitutional orders. B. Exclusion of evidence. Courts may exclude evidence obtained in violation of rights. C. Administrative and labor law remedies. Constitutional violations may lead to administrative or labor-related remedies. 8.8. Remedies for private violations of rights. Courts develop remedies for non-state actors infringing constitutional rights. Next page. Study notes. Key constitutional provisions on remedies. Section 38. Enforcement of rights grants standing to anyone listed to approach a competent court for relief. Court can grant appropriate relief, including declarations of rights, interdicts, damages, other constitutional remedies. Section 172. Powers of courts in constitutional matters. 1a. Courts must declare any inconsistent law or conduct invalid. 1b. Courts may make any just and equitable order, including I. Limiting retrospective effect of invalidity. 2. Suspending the declaration of invalidity to allow correction of the defect. Section 8. Application of the Bill of Rights. 3a. Courts must develop or apply common law if legislation does not give effect to a right. 3b. Courts may develop common law rules to limit rights, subject to S36, Limitations Clause. Section 39. Interpretation of the Bill of Rights. 2. Courts must promote the spirit, purport, and objects of the Bill of Rights when interpreting legislation. Developing common law or customary law. Next page. Study notes. Chapter 8. Remedies. 8.1 Constitutional remedies and the other stages of Bill of Rights litigation. A. Constitutional remedies and the application of the Bill of Rights. Indirect application, reading down legislation, Common law development, covered in Chapter 3. Direct application of Bill of Rights leads to constitutional remedies under Section 8, Application of the Bill of Rights. Section 38, Courts may grant appropriate relief for rights violations. Section 172, Courts may make any just and equitable order in constitutional matters. Courts have developed existing remedies and created new remedies to vindicate constitutional rights. B. Remedies in standing. Applicant must allege violation or threat to a fundamental right, sufficient interest in the remedy sought. S38. Courts take a broad approach to standing, so sufficiency of interest is rarely a barrier. C. Remedies and jurisdiction. Availability of constitutional remedies depends on jurisdiction. Magistrates' courts and statutory tribunals, limited to jurisdiction granted by enabling legislation, previously had little jurisdiction to apply the Bill of Rights beyond criminal law. Equality courts, under PEPUTA, Promotion of Equality and Prevention of Unfair Discrimination Act 4 of 2000, now handle equality disputes. Administrative justice disputes also fall within magistrates' jurisdiction. PAHA, Promotion of Administrative Justice Act, expands high court jurisdiction. Affected party can litigate where they are domiciled or where the harm is experienced. Example, a KwaZulu-Natal company can sue the city of Johannesburg and Durban. D. Remedies, interpretation, and limitation. Sanderson v. Attorney General, Eastern Cape. Courts' flexibility in granting remedies affects how they interpret rights. A wide range of remedies encourages courts to find violations, as they are not limited in redress options. Remedies require pragmatic rather than rigid legal interpretation. Courts focus on practical outcomes. Underscore 8.2 Difference between invalidity of unconstitutional law/conduct and constitutional remedies. Fos v. Minister of Safety and Security. Supremacy clause means unconstitutional law/conduct is automatically null and void. However, invalidity must be declared by a court before it has real-world effect. Section 172(1). Courts must declare unconstitutional law/conduct invalid. Courts may also grant further just and equitable remedies beyond invalidation. The role of declarations of invalidity aligns real-world law with the constitutional framework. May require additional positive actions, such as reading and missing provisions. Mandamus, ordering a state body to act. Structural interdicts, supervised compliance. Private rights violations. Invalidation is ineffective as a remedy for private conduct. Section 8(3) requires courts to look for legislative remedies first. If no remedy exists, turn to common law. If neither applies, courts must develop an appropriate remedy. Categories of constitutional remedies. 1. Declarations of invalidity. 2. Declarations of rights. 3. Prohibitory and mandatory interdicts. 4. Awards of constitutional damages. Further sections will explore specific constitutional remedies in detail. Next page. Study notes, Constitutional Remedies and Bill of Rights litigation. 8.1 Constitutional Remedies and the other stages of Bill of Rights litigation. A. Constitutional remedies and the application of the Bill of Rights. Indirect application of the Bill of Rights includes reading down legislation and developing common law. Direct application leads to constitutional remedies under SS 8, 38, and 172 of the Constitution. Section 38, Courts may grant appropriate relief for rights violations. Section 172, Courts may issue orders that are just and equitable. Courts have developed common law remedies and created new constitutional remedies. B. Remedies in standing. To have standing, an applicant must allege a fundamental right has been violated or threatened, a sufficient interest in the remedy, assessed based on the remedy sought. Courts adopt a broad approach to standing, ch. 4, so it is rarely a barrier. C. Remedies and jurisdiction. Jurisdiction determines availability of constitutional remedies. Some courts have limited subject matter and remedial competence, ch. 5. Magistrates' courts have no inherent jurisdiction and rely on enabling statutes. Equality courts, under PEPUTA, 2000, allow magistrates to apply Bill of Rights in equality disputes. Promotion of Administrative Justice Act expands high court jurisdiction. For example, a KwaZulu-Natal company can sue Johannesburg and Durban. D. Remedies, interpretation, and limitation. In Sanderson v. Attorney General, Eastern Cape, Remedies influence the interpretation of rights. A broad discretion in remedies encourages findings of rights violations. Courts are less hesitant. Remedy decisions require a pragmatic approach, the art of the possible. Underscore. 8.2 Difference between invalidity of unconstitutional law or conduct and constitutional remedies. Infos v. Minister of Safety and Security, Kriegler J. Supremacy Clause renders unconstitutional laws/conduct a nullity. Inconsistency equals automatic invalidity, but a court order is needed to enforce it. Section 172(1). Courts must declare unconstitutional laws/conduct invalid. Invalidity does not equal remedy. Additional court orders may be needed, such as reading in, mandamus, structural interdicts, private violations. Section 8.3. Courts must first seek remedies in legislation or common law before developing a new remedy. 4 major types of constitutional remedies. 1. Declarations of invalidity. 2. Declarations of rights. 3. Prohibitory and mandatory interdicts. 4. Awards of constitutional damages. Underscore. 8.3 Appropriate relief and the flexible approach to constitutional remedies. Section 38 requires appropriate relief but does not define it. Section 172 allows just and equitable orders. Flexible approach. No single prescribed remedy. Courts determine remedies case by case. Underscore. 8.4 Purpose of constitutional remedies. Violation of constitutional rights harms both the individual and society. Remedies must vindicate the Constitution and deter future violations. Ensure public faith in the Constitution. Be forward-looking and structural rather than retrospective and individualistic. Metrorail case. Private law damages may not always be appropriate. Public law remedies aim to correct improper actions and ensure efficient governance. Later Constitutional Court ruling. Public law remedies should preempt, correct, or reverse unconstitutional actions. Underscore. 8.5 Factors in awarding constitutional remedies. 1. Effectiveness of the remedy. Hoffman v. South African Airways. Court ordered appointment of an HIV-positive job applicant. Striking at the source of the infringement is crucial. 2. Public interest considerations. Constitutional cases have a wider public dimension. Courts must consider implications for all similarly affected individuals. 3. Good governance. Courts avoid remedies that create serious inconsistencies in legislation. 4. Separation of powers. Courts should defer to the legislature except when necessary to prevent a constitutional violation. Courts avoid ordering legislatures to pass specific laws. 5. Identity of the violator. Public versus private violations. Remedies may vary in deterrent effect. Institutional violations. Courts may remit decisions to institutions for correction. 6. Nature of the violation. Systemic violations require structural remedies and institutional supervision. 7. Impact on the victim. Imprisonment-related violations require immediate relief, no suspension of invalidity. 8. Fault and causation. Relevant when awarding constitutional damages. 9. Victim responsibility. Sanderson case. Courts consider whether the victim contributed to the harm, for example, delays in trial. 10. Implementation feasibility. Courts must ensure remedies are enforceable and practical. Consider budgetary constraints and likelihood of compliance. Orders should be clear, precise, and within institutional capacity. Next page. Study notes on constitutional remedies. 8.3 Appropriate relief and flexible approach to constitutional remedies. Section 38. Remedy for a violation of the Bill of Rights must be appropriate. No specific remedies are prescribed beyond. Section 172. Declaring unconstitutional laws/conduct invalid. Section 8.3. Providing necessary relief. Flexible approach. Courts determine what is just and equitable in each case. 8.4. Purpose of constitutional remedies. Harm of constitutional violations. Affects not just the individual but society as a whole. Impedes constitutional goal of a just, democratic society. Objectives of constitutional remedies. Vindicate the Constitution. Deter future violations. Maintain public faith in the Constitution. Prevent recurrence of the harm. Forward-looking, community-oriented, and structural. Not just private law damages, for example, Metrorail case. Public law remedies focus on preempting/correcting actions. 8.5. Factors in awarding constitutional remedies. 1. Effectiveness. Remedies must strike at the source of the infringement, for example, Hoffman v. South African Airways. 2. Wider public interest. Court orders should provide relief beyond the individual litigant. 3. Good governance. Avoid remedies causing inconsistencies in legislation. 4. Separation of powers. Courts should not intervene in legislative processes unless necessary. 5. Identity of the violator. Public/private distinction affects remedy choice. 6. Nature of violation. Systemic violations may require structural remedies. 7. Impact on the victim. Severe rights violations, for example, imprisonment, require urgent remedies. 8. Fault and causation, relevant for constitutional damages. 9. Victim responsibility, may influence remedial decisions, for example, Sanderson case. 10. Implementation feasibility, remedies must be clear, enforceable, and financially viable. _ 8.6 Constitutional remedies. A. Declarations of invalidity. I. General principles. Default remedy, Declaration of Invalidity, S-172-1A. Supremacy of Constitution. Courts must declare unconstitutional laws/conduct invalid. Impact regulation. Courts may sever unconstitutional provisions, read in missing provisions, control retrospective effects, suspend declarations temporarily. Legislative response. Courts eliminate unconstitutional provisions but do not dictate replacements. Preference for narrow rulings to allow legislative reform. Jurisdiction. High courts, SCA, and CC can declare laws invalid. CC confirmation required for acts of Parliament, provincial laws, and presidential conduct. Temporary relief may be granted pending CC confirmation. 2. Controlling the impact of a declaration of invalidity. AA. Severance. Principle. Invalid provisions must be severed while retaining constitutional portions. Two-part test, Coetzee case. 1. Can the invalid provisions be severed? 2. Does what remains still serve the legislative purpose? Types of severance. Actual severance, physically removing words/phrases. Notional severance, keeping language but adding conditions, for example, Ferreira v. Levin. Limitations. Notional severance cannot fix omissions, for example, National Coalition for Gay and Lesbian Equality. Actual severance preferred for clarity. Challenges. Legislative purpose must be considered holistically, for example, Case B. Minister of Safety and Security. Judicial divisions in applying severance, for example, S. v. Coetzee. Next page. Reading in of words. Distinction from reading down. Reading down, statutory interpretation method per S. 39(2) of the Constitution, ensuring consistency between law and the Constitution within reasonable textual meaning. Reading in, a constitutional remedy applied after a statute is deemed unconstitutional, adding words to cure an omission. Relation to severance. Severance removes unconstitutional parts of a statute. Reading in, used when unconstitutionality stems from omission, permitted under S. 172 of the Constitution. Both ensure minimal interference with legislation. Key considerations for reading in. The court must define precisely how the statute should be extended. Must align with the legislative scheme while complying with the Constitution. Should not impose excessive budgetary burdens. Proportionality in extending benefits matters. Judicial precedents. Would-be Minister of Home Affairs. Courts avoid reading in when multiple legislative solutions exist, respecting separation of powers. National Coalition for Gay and Lesbian Equality v. Minister of Home Affairs. Extended benefits to same-sex life partners in line with government policy and minimal budget impact. S. v. Manamala and S. v. Singo. Reading in applied to modify overly invasive provisions, for example, replacing reverse onus presumption with evidential presumption. Growing use of reading in. Increasingly preferred due to failures of suspension orders. Ensures an immediate, constitutionally compliant solution while allowing legislative amendment. Controlling the retrospective effect of invalidity orders. General principle. Constitutional supremacy makes unconstitutional laws null and void automatically. Court declarations confirm invalidity rather than create it. Default effect. Retrospective invalidation from the Constitution's commencement or the statute's enactment, whichever is later. Risk of disruption. Retrospective invalidation can affect past actions taken in good faith. Example, Invalidating a reverse onus presumption could overturn past convictions. Section 172(1)(bi) allows courts to limit retrospective effects when necessary for justice and equity. Burden on the party seeking limitation to justify its necessity. Judicial approach. Courts balance avoiding disruption with providing effective relief. Courts generally avoid overturning finalized cases, prevent exposing individuals to retroactive civil or criminal liability, grant relief to all similarly affected, not just the litigants. Typical practice. Courts issue prospective invalidity orders while allowing limited retrospective application, for example, for ongoing appeals. If no explicit limitation, invalidity applies retrospectively to February 4, 1997, 1996 Constitution's commencement. Next page. Reading in of words. Distinction between reading in and reading down. Reading down, a method of statutory interpretation under S. 39(2) to avoid constitutional inconsistency by interpreting statutes in line with the Constitution. Limited to the reasonable meaning of the text. Reading in, a constitutional remedy applied after a statute is declared unconstitutional. Adds words to cure omissions, distinct from severance, which removes unconstitutional provisions. Conditions for reading in. Must remove constitutional inconsistency while minimizing legislative interference. Requires precision in defining how the statute should be extended. Must align with legislative intent within constitutional limits. Should not cause an unsustainable budgetary impact. Judicial approach to reading in. Inda would be Minister of Home Affairs. Court avoided reading in due to multiple legislative solutions available, respecting the separation of powers. In National Coalition for Gay and Lesbian Equality v. Minister of Home Affairs, first use of reading in to extend spousal benefits under the Aliens Control Act 96 of 1991 to same-sex partners, aligning with government policy. Used frequently to remedy discriminatory statutes excluding same-sex life partners from spousal benefits. In S. v. Manamala, Court used reading in to replace an unconstitutional reverse onus presumption with an evidential presumption, expanding its application beyond under-inclusive provisions. Advantages and increasing use of reading in. Provides immediate constitutional compliance, avoiding negative consequences of suspension orders, can be modified by the legislature at any time. Underscore. Controlling the retrospective effect of orders of invalidity. Principle of retrospective invalidation. Constitutional supremacy renders unconstitutional laws void from the time the Constitution or legislation came into effect. Courts confirm invalidity rather than create it. Ex tunc effect. Need to limit retrospective effects. Unchecked retrospective invalidation can disrupt legal certainty, for example, invalidating past criminal convictions based on unconstitutional laws. Section 172(1)(bi) allows courts to limit retrospective application for justice and equity. Balancing factors considered by courts. Weighs disruption of retrospective invalidation against providing effective relief to affected individuals. Courts generally avoid overturning finalized cases or exposing individuals acting in good faith under invalid law to liability. Full retrospective effect may be granted to avoid patent injustice. Courts' approach to partial retrospectivity. Usually, courts limit retrospectivity to cases where appeals are pending or time to appeal has not expired. If an order is silent, invalidation applies retrospectively to February 4, 1997, start of the 1996 Constitution. Underscore. Suspension of orders of invalidity. Purpose and legal basis. Section 172(1)(b) 2 allows courts to suspend a declaration of invalidity, giving the legislature time to rectify defects. If the legislature acts within the suspension period, the invalidity declaration falls away. Otherwise, invalidity takes effect upon expiry. Effects of suspension. The unconstitutional law remains in force until the expiry of the suspension period. Courts may grant interim relief to litigants affected by the unconstitutional law. Factors considered in granting suspension. Whether invalidation would create a legal vacuum or disrupt regulatory frameworks. Avoidance of unsustainable budgetary intrusion. Whether alternative statutory provisions can function without the invalidated provision. If the unconstitutional law is manifestly indefensible, courts will refuse suspension. Judicial practice on suspension orders. Suspension orders are now usually accompanied by interim relief or transitional measures to balance justice and equity. Courts rarely grant suspension without additional safeguards. Suspension without more. Extension of suspension period. Courts can extend suspension if justified and applied for before expiry, Minister for Justice and Constitutional Development Vignati cannot be extended after expiry, as invalid legislation cannot be revived. Next page. Here's a structured summary of your provided text. Underscore. Suspension of orders of invalidity. Purpose and effect of suspension power. Section 172 1b, 2, of the Constitution allows courts to suspend the effect of a declaration of invalidity for a set period. Purpose. Gives Parliament, or competent authority, time to correct the defect. If the defect is rectified, the declaration falls away, and prior actions under the law remain valid. If not rectified, the invalidity takes effect at the end of the suspension period. The legislature is not obligated to correct the defect. It can choose to rectify the invalidated law, address the consequences of invalidity through other means, take no action, allowing the declaration to take effect. The law remains in force during suspension. Courts may grant interim relief to mitigate rights violations. Courts should consider providing immediate relief where necessary. Factors relevant to suspension. Immediate invalidation is the default unless persuasive reasons justify suspension. The burden is on the state to prove suspension is necessary. Court requires evidence of adverse consequences of immediate invalidation. Why existing measures would not suffice. Whether a new law is already in progress. Time needed to correct the defect. Cases where suspension is appropriate. Avoiding a regulatory vacuum. Preventing budgetary crises. When immediate invalidation would be unconscionable, for example, clear violations of fundamental rights. The Constitutional Court often combines suspension orders with an interim regime. Extension of suspension period. The legislature may apply for an extension before the suspension expires. Courts can reconsider the period of suspension and its conditions where necessary. Key cases. Minister for Justice and Constitutional Development Vignati confirmed courts may extend suspension. Zondi v. Mech. Traditional and Local Government Affairs. Courts should extend only if just and equitable. Courts cannot revive an unconstitutional law after expiry of the suspension period. Underscore. Declarations of rights. Section 38 allows courts to grant a declaration of rights even if no law is declared invalid. Differences from a declaration of invalidity. Declaration of rights settles a dispute between parties. Declaration of invalidity is binding on all. Judicial discretion. Courts are not obliged to issue a declaration of rights. JT Publishing v. Minister of Safety and Security. Declaratory relief may be granted without additional remedies. President of RSA v. Hugo. Key cases. Metrorail. Declaratory orders clarify rights but leave implementation to government. Treatment Action Campaign. Court rejected the idea that declaratory orders are the only remedy in socio-economic rights cases. Underscore. Interdictory relief. General principles. Interdicts, injunctions, are forward-looking remedies suited to constitutional litigation. The Constitutional Court favors interdicts over damages in constitutional cases. Key case. City Council of Pretoria v. Walker. Interdicts are more appropriate than dismissing claims. Types of interdicts. I. Interim relief. Preserves status quo until final judgment. Courts apply common law requirements. Prima facie right. Irreparable harm if relief is not granted. No alternative remedy available. Balance of convenience favors the applicant. Separation of powers. Courts avoid interim orders that intrude excessively into executive functions. Key case. President of RSA v. UTM. Courts generally do not suspend laws via interim relief but may prevent harm caused by their implementation. 2. Final interdicts. Common law requirements apply. Clear right. Injury occurred or is reasonably apprehended. No alternative remedy available. Mandamus, compelling an action. Used when the government fails to act on a constitutional duty, found in Promotion of Administrative Justice Act 3 of 2000. Key case. MEC for Education, KZN v. Pillay. Court ordered a school to change its code of conduct to accommodate religious and cultural rights. Underscore. This summary captures the key legal principles, relevant constitutional provisions, and important case law while keeping the structure clear and organized. Let me know if you need any refinements. Next page. Structural interdicts and similar relief. Definition and purpose. A structural interdict is a court order directing a violator, usually the government, to rectify a breach of fundamental rights under court supervision. It is a remedial tool designed to ensure compliance with constitutional obligations, especially in cases involving socio-economic rights and positive state duties. 5 elements of a structural interdict. 1. Declaration of breach. Court identifies how the government has failed to meet its constitutional obligations. 2. Compliance order. Government is ordered to rectify the violation. 3. Reporting obligation. Government must submit a report, usually under oath, within a set period detailing actions already taken, planned future measures. 4. Applicant's response. The applicant, or affected party, is given the chance to respond to the government's report. 5. Court supervision. The matter is scheduled for a further hearing. If the court is satisfied, the report becomes an order of court. Non-compliance may lead to contempt of court proceedings. Use of structural interdicts in South African constitutional law. High courts have used structural interdicts early on to enforce socio-economic rights and other positive obligations. The Constitutional Court initially granted limited structural interdicts but has increasingly used them, especially in eviction cases. Judicial supervision in eviction cases. Courts issue supervisory orders to ensure meaningful engagement between evictees and government. Government is required to engage in discussions regarding eviction timelines and relocation. Report back to the court on agreements reached. Meet court-imposed housing standards for temporary accommodation. In some cases, allocate a specific percentage of new low-cost housing to evictees. Justification for structural interdicts. Only effective remedy in cases requiring long-term government action. Ensures government accountability, as per Plaskett J's reasoning. Supports democratic values of accountability, responsiveness, and openness. Guarantees a formal government response to constitutional violations. Challenges and limitations. Judicial overreach. Courts risk intruding into governance, a role better suited for the executive. Separation of powers concern. Courts must ensure supervision remains flexible and does not become excessively intrusive. Difficult to exit. Once a court assumes supervisory jurisdiction, it may struggle to extricate itself from ongoing governance matters. Underscore. This summary maintains a clear structure while capturing key legal principles, case law, and judicial considerations. Let me know if you need any refinements. Next page. Damages as a constitutional remedy. General principles. The Constitution does not prevent courts from awarding damages for violations of fundamental rights. However, the Constitutional Court's jurisprudence has been cautious about using damages as a remedy. Constitutional remedies should be forward-looking, community-orientated, and structural, whereas damages focus on past harm and compensation. Challenges in awarding constitutional damages. Steenkamp. No case of breach of a constitutional duty is not necessarily wrongful in the delictual sense. To justify damages, the breach must also be unreasonable according to community justice standards. Courts are more likely to award damages if the government acted in bad faith, corrupt circumstances, outside the legitimate scope of its authority. Need for constitutional damages. Some situations require damages as the only effective relief, for example, workers forced to work on election day, preventing them from voting. Police breaking up a lawful demonstration on political orders. Religious discrimination, such as preventing a Christian from attending church on Christmas. A mere declaration of rights may be insufficient. Damages are necessary to vindicate rights and deter future violations. The prospect of substantial damages awards may encourage victims to litigate, promoting constitutional accountability. Court practice in awarding constitutional damages. High courts and the Supreme Court of Appeal have awarded constitutional damages in cases where no other relief was suitable. Key cases include social assistance grant maladministration, failure to evict unlawful occupiers from private land. Foes v. Minister of Safety and Security, 1997, facts. The plaintiff was assaulted and tortured by the police. He claimed delictual damages and additional constitutional damages for violations of dignity and the prohibition against torture. He argued constitutional damages would 1. Vindicate fundamental rights. 2. Deter future violations. 3. Punish state officials for egregious breaches. Court's decision. Awarding additional constitutional damages was unnecessary because delictual damages sufficiently vindicated the plaintiff's rights. Punitive damages were rejected as an ineffective deterrent and an inappropriate use of public funds. Funds should be allocated to structural reforms rather than compensating individuals beyond delictual remedies. Principles established in FOS. 1. Constitutional damages are rarely awarded when delictual damages are available, to avoid punitive compensation. 2. Even in cases without delictual damages, constitutional damages are not guaranteed. Courts may opt for declaratory relief and a costs order instead. 3. Development of delictual claims under the Bill of Rights is preferred over separate constitutional damages. 4. Causal connection. As held in Van Abo, a plaintiff must prove that their loss was directly caused by the constitutional rights violation. Expansion of state liability in Carmichael v. Minister of Safety and Security. This case expanded state liability for personal injuries caused by negligent state actions. Unlike personal injury claims, there has not yet been a similar expansion for pure economic loss caused by negligent administrative decisions. This summary provides a structured and in-depth overview. Let me know if you need any refinements. Next page. Study notes. Damages as a constitutional remedy. 1. General principles on constitutional damages. The Constitution does not prevent courts from awarding damages for the violation of fundamental rights. Constitutional remedies are ideally forward-looking, structural, and community-oriented. Damages, by nature, focus on compensating past harm rather than preventing future violations. The Constitutional Court, CC, in Steenkamp No held that a constitutional or statutory breach is not automatically wrongful in a delictual sense. Compensation is only justified where an administrative decision is made in bad faith, corrupt circumstances, or completely outside the scope of authority. 2. Justifications for constitutional damages. Certain violations render declaratory relief or interdicts ineffective, making damages the only appropriate remedy. Prevented from voting due to employer coercion. Lawful demonstrations unlawfully stopped by police. Religious rights violated, for example, prevented from attending church. Encouraging litigation. Potential damages awards incentivize victims to enforce constitutional rights. 3. Key case law on constitutional damages. Foes v. Minister of Safety and Security, 1997. Plaintiff sued for damages after being tortured by police. Claimed both delictual damages and additional constitutional damages for rights violations. Objectives of constitutional damages. 1. Vindication of fundamental rights and constitutional values. 2. Deterrence of future violations by the state. 3. Punishment of egregious rights violations by state officials. CC ruling. Delictual damages were sufficient. No additional constitutional damages awarded. Punitive damages rejected. Public funds should address systemic causes rather than individual compensation. General principles from Foes. 1. Constitutional damages are rare where delictual damages exist. 2. Even without delictual damages, constitutional damages are not guaranteed. 3. Development of delictual law preferred over separate constitutional damages claims. 4. Causation requirement. Claimants must show a clear causal link between the constitutional violation and their loss. Van Abo case. 4. Indirect application and development of new damages claims. Section 12 of the Constitution, right to freedom and security of person, has greatly influenced personal injury law. Promotion of Administrative Justice Act, PAJA, 3 of 2000 allows courts to order compensation in exceptional cases. Supreme Court of Appeal, SCA, cautious on economic loss claims. Rejected claims for negligent tender awards and unlawful planning decisions. Allowed fraud-based loss of profit claims in tender cases. 5. Direct constitutional damages claims. Motorclip cases. Large group illegally occupied private farmland, eviction delayed due to state inaction. Courts issued various orders. High Court, structural interdict requiring government to provide a solution. SCA, ordered state to compensate landowner for loss of land use under Expropriation Act 63 of 1975. CC upheld the SCA ruling, recognizing damages as the most effective remedy. 2. Social assistance cases, Eastern Cape and KwaZulu-Natal. Widespread corruption led to unlawful termination of social grants. Permanent Secretary, Department of Welfare, Eastern Cape Think Souza. High Court ruled that grant terminations without hearings were unlawful. Further litigation due to delays in grant processing. High courts substituted their own decisions for government in awarding grants. JE of EMEC for Welfare, Eastern Cape, SCA, criticized this practice as ignoring PAHA. CC later upheld reinstatement of unlawfully terminated grants with back pay and interest. Enforcement issues and systemic response. Provincial governments failed to comply with damages orders, leading to contempt of court litigation. Judicial response, pre-litigation directives to encourage settlements. Political response, creation of SASA to centralize social grant administration. _ 6. Structural relief versus individual compensation. Courts face a trade-off between short-term relief, constitutional damages, for individuals, long-term, systemic reform, structural interdicts, to prevent future violations. Structural relief aligns with the forward-looking nature of constitutional remedies. Next page. Study notes on indirect application, constitutional damages, and other forms of relief. 8.6 Indirect application and the development of new damages claims. 2. Indirect application and new damages claims. Impact of Section 12 of the Constitution. Chapter 12 discusses how S12, right to freedom and security of the person, has influenced personal injury law. Promotion of Administrative Justice Act 3 of 2000, PAJA. Allows courts in exceptional cases to order compensation in administrative review proceedings. Economic loss in administrative decision-making. Courts adopt a cautious approach to claims for pure economic loss from negligent administrative actions. Key cases. Rejected claims. Loss of profit due to the negligent award of a tender. Loss caused by unlawful land use planning decisions. Allowed claims. Loss of profit where a tender was fraudulently awarded to another. Current legal position. Claims for loss of profit require intentional wrongdoing. Out-of-pocket expenses, for example, costs of materials, could be considered even for negligence. 3. Damages claims derived directly from the Constitution. 1. Motorclip cases, property versus housing rights, facts. 36,000 squatters occupied private land. Eviction order granted, but the sheriff required $1.8 million for enforcement. State refused to contribute to eviction costs. Legal developments. High Court ordered the government to produce a relocation plan, SCA. Declared both landowners' property rights and squatters' housing rights were infringed. Allowed squatters to remain until alternative housing was provided. Ordered constitutional damages for landowner under the Expropriation Act 63 of 1975. Constitutional Court affirmed that compensation was the appropriate remedy. 2. Social assistance cases, delays in processing grants, background. Corruption in grant allocation in Eastern Cape and KZN led to mass terminations. Beneficiaries challenged terminations for lack of due process. Key cases. Permanent Secretary, Department of Welfare, Eastern Cape Vink Souza. Grants were reinstated due to procedural unfairness. Further legal developments. Judicial intervention. Courts substituted their own decisions for delayed government actions. Ordered back pay and interest. Became an alternative forum for processing grants. Supreme Court of Appeal, JEA case. Criticized courts for ignoring PAHA, which only allows compensation in exceptional cases. Constitutional Court only ruled on grant reinstatements and back pay, not systemic reform. Non-compliance with court orders. Provinces failed to pay constitutional damages, leading to contempt of court cases. Judiciary introduced pre-litigation directives to encourage engagement with state attorney's office. Government created SASA to handle grant administration. 3. Tension between remedies. Individual damages versus systemic reform. Courts can award constitutional damages to litigants. Alternatively, courts can grant structural relief to fix systemic issues. Damages provide immediate relief but do not address broader issues. _ 8.7 Other forms of relief. A. Contempt of court. General rule. Non-compliance with mandatory court orders can lead to a contempt of court declaration and criminal sanctions, fine or imprisonment. Requires a rule nisi before imposing sanctions. Standard of proof, beyond a reasonable doubt. Elements. Failure to comply with court order. Willful and mala fide conduct. Contempt for non-payment of money. Common law position. A person cannot be held in contempt for failing to pay a money judgment. Social assistance cases. Courts developed common law to allow contempt charges for non-payment by government. SCA and JEA v MEC for welfare, Eastern Cape. Rejected this development. Ruled that courts cannot retrospectively create new criminal offenses. Unfair to hold officials in contempt for failing to pay state debts when individuals are not held in contempt for private debts. State liability in the Athi case. State Liability Act 20 of 1957. prohibits execution against state assets. Led to a constitutional challenge. Niathi v. Mek for Health. Hauteng. Court found that existing procedures to enforce judgments against the state were ineffective. Ordered Parliament to amend the procedures. However, rejected direct contempt liability for officials. B. Exclusion of evidence. Illegally obtained evidence can be excluded in both civil and criminal cases as a constitutional remedy. C. Administrative and labor law remedies. Administrative justice, PAJA. PAJA remedies, setting aside, substitution, compensation in exceptional cases, apply in constitutional cases. Labor law. Remedies like reinstatement apply in employment-related constitutional violations. _ 8.8 Remedies for private violations of rights. Application of Section 8.3. Section 8.3 of the Constitution guides courts in applying the Bill of Rights to private conduct. Three-step approach. 1. Legislation. Look for a statutory remedy. 2. Common law. If no statutory remedy exists, apply common law. 3. Development of common law. If common law is inadequate, develop a new remedy. Principle of constitutional avoidance. Complainants must first exhaust ordinary legal remedies before relying directly on the Constitution. Example, preventing a voter from voting. Step 1. Check existing statutory remedies. Electoral Act criminalizes interference with voting rights. Remedy, filing a criminal complaint. Step 2. Indirect application of Bill of Rights. Develop common law remedies, for example, actio injuriarum, for dignity harm. Step 3. Direct application of the Bill of Rights. If statutory and common law remedies are inadequate, courts can create a new constitutional remedy, for example, damages. Ensuring appropriate remedies. Courts must assess whether existing remedies adequately protect constitutional rights. If not, a new constitutional remedy should be developed. _ Key takeaways. Indirect application affects damages claims, particularly in economic loss and administrative law. Constitutional damages can be awarded where state failures infringe rights, for example, Motorclip and social assistance cases. Contempt of court applies to non-compliance with mandatory orders but generally not for failure to pay money judgments. JEA. Exclusion of evidence is a constitutional remedy. Administrative and labor law remedies apply in constitutional cases. Private violations of rights follow a structured approach. Statutory remedy, common law, development of a new remedy. Courts ensure that any remedy awarded properly protects fundamental rights. Next page. Here are your structured study notes for Chapter 9, Equality. _ 9.1 The Constitutional Commitment to Equality. A. The concept of equality. Equality is a foundational value in the Constitution. It includes both formal equality, treating everyone the same, and substantive equality, addressing past injustices. B. The historical and social context of the right to equality. The history of apartheid and discrimination necessitated a strong constitutional commitment to equality. The legal framework aims to redress past injustices and prevent ongoing discrimination. C. Formal and substantive equality. Formal equality, treating everyone the same, irrespective of differences. Substantive equality, recognizing that equal treatment may reinforce disadvantages, thus requiring affirmative action or special measures. _ 9.2 Interpreting Section 9. A. Section 9 compared to Section 8 of the Interim Constitution. Section 9 of the final Constitution expands and clarifies equality protections compared to Section 8 of the Interim Constitution. B. The stages of inquiry. 1. Does the differentiation amount to discrimination? 2. If so, is the discrimination unfair? 3. If unfair, can it be justified under Section 36, the Limitations Clause? C. The relationship between Section 9 and Section 36. Section 9 prohibits unfair discrimination, but it may still be justified under Section 36 if reasonable and justifiable. _ 9.3 Mere differentiation. A. Differentiation and discrimination distinguished. Differentiation, any distinction between groups or individuals. Discrimination, differentiation based on prohibited or analogous grounds, leading to disadvantage. B. Rationality. Any differentiation must have a rational connection to a legitimate government purpose. C. Section 9(1) in Rule of Law Rationality. The rule of law requires that differentiation must not be arbitrary or irrational. D. Differentiation between provinces. The Constitution permits differentiation between provinces where justified by practical governance needs. Underscore. 9.4 Discrimination. A. The concepts of discrimination and unfair discrimination. Discrimination, any differentiation based on listed or analogous grounds. Unfair discrimination, causes harm or disadvantage, violating dignity. B. Unfair impact. The impact on the affected group determines unfairness, not just intent. C. The presumption of unfair discrimination. Section 9.5. Discrimination on a listed ground is presumed to be unfair, unless proven otherwise. D. Fair discrimination. Not all discrimination is unfair, for example, affirmative action, reasonable accommodation for disabilities. E. Unfair discrimination. Discrimination is unfair if it reinforces systemic disadvantages or undermines dignity. F. The listed grounds. Race, color, ethnic origin, apartheid history makes these grounds particularly sensitive. Gender, sex, pregnancy, protections against gender-based discrimination, including maternity rights. Sexual orientation. AA. Decriminalization, homosexuality decriminalized in National Coalition for Gay and Lesbian Equality v. Minister of Justice. BB. Exclusion from benefits, unconstitutional to deny same-sex partners benefits available to married couples. CC. Exclusion from marriage, Minister of Home Affairs v. Fourie recognized same-sex marriage. Marital status, protection against discrimination based on whether a person is married, divorced, or single. Age, protection against age-based discrimination, unless justified. Disability, requires reasonable accommodation to prevent indirect discrimination. Religion, conscience, belief, culture, and language, rights must be balanced against constitutional values. Birth and social origin, includes discrimination based on illegitimacy or family status. G. Not defamatory to depict someone as having any of the listed characteristics. A depiction is not defamatory if it suggests that a person belongs to a protected group. H. The analogous grounds. Courts have expanded equality protections beyond the listed grounds to include additional forms of discrimination. I. Direct and indirect discrimination. Direct discrimination, explicit and intentional exclusion based on a characteristic. Indirect discrimination, neutral policies that disproportionately disadvantage a group. J. Discrimination need not be intentional. Unintentional discrimination can still be unconstitutional if it has an unfair impact. Underscore. 9.5 Affirmative action. Section 9.2 permits affirmative action to address historical disadvantages and promote substantive equality. Affirmative action is not unfair discrimination but a constitutional obligation. Underscore. 9.6 The Promotion of Equality and Prevention of Unfair Discrimination Act, PEPUDA A. Prevention of Unfair Discrimination. PEPUDA prohibits unfair discrimination in both public and private sectors. Defines hate speech and harassment as forms of unfair discrimination. B. Access to justice. Equality courts established to provide accessible and affordable remedies for discrimination claims. C. Promotion of equality. PEPUDA places positive obligations on the state and private parties to proactively promote equality. Underscore. This structured summary follows your preferred study note format, highlighting key constitutional provisions, case law, and legal principles. Let me know if you need further details or specific case law elaboration. Rocket emoji. Next page. This is Section 9 of the Constitution of South Africa, which guarantees equality and prohibits unfair discrimination. Here's a structured breakdown of its key provisions. Underscore. Section 9, Equality. 1. Right to equality before the law. Everyone is equal before the law. Everyone has the right to equal protection and benefit of the law. 2. Substantive equality and affirmative action. Equality includes full and equal enjoyment of all rights and freedoms. To achieve substantive equality, the state may adopt legislative and other measures to advance persons disadvantaged by unfair discrimination. This provision justifies affirmative action. 3. Prohibition of unfair discrimination by the state. The state may not unfairly discriminate, directly or indirectly, on any of the following listed grounds: race, gender, sex, pregnancy, marital status, ethnic or social origin, color, sexual orientation, age, disability, religion, conscience, belief, culture, language, and birth. 4. Prohibition of unfair discrimination by private persons. No private person may unfairly discriminate against another on any of the listed grounds. National legislation must be enacted to prevent and prohibit unfair discrimination. PEPUDA gives effect to this. 5. Presumption of unfairness. Discrimination on a listed ground is presumed to be unfair, unless the discriminator proves it is fair. This shifts the burden of proof to the person or entity accused of discrimination. _ These provisions establish the constitutional foundation for equality law in South Africa, ensuring both formal and substantive equality, and prohibiting unfair discrimination in both public and private spheres. Rocket emoji. Next page. Study Notes, Chapter 9, Equality. 9.1 The Constitutional Commitment to Equality. A. The concept of equality. Equality is a complex and contested social ideal. Formal equality: people similarly situated should be treated similarly, those not similarly situated should be treated differently. Example: denying women the vote is wrong as men and women are similarly situated in exercising political choices. Denying children the vote is justified as they lack the same political maturity as adults. Two key issues in defining equality. 1. Determining relevant similarities. Are men and women similarly situated for military service based on physical strength? 2. Defining equal treatment. Should blind children attend the same schools as sighted children, or should special accommodations be made? The Constitution mandates a commitment to achieving equality. Section 9. Equality includes equal protection and benefit under the law, prohibition of unfair discrimination, substantive equality measures, affirmative action, for historically disadvantaged groups. S92. B. Historical and social context of equality. Apartheid entrenched systematic racial and socio-economic inequality. Constitutional Court recognition: apartheid discriminated against black South Africans in all spheres. Land ownership, restricted to 10% of the country. Employment, senior positions reserved for whites. Education, limited access to quality schools and universities. Public facilities, segregation in transport, parks, libraries, and services. Post-apartheid inequality. White South Africans still enjoy better living conditions, health, education, and economic opportunities. Black South Africans suffer higher infant mortality rates, lower life expectancy, and extreme poverty. Women, especially African women, are the most socio-economically disadvantaged. Shifting inequality patterns. While race-based inequality is decreasing, intra-racial inequality is rising. Top 20% of African households have become wealthier, while bottom 40% have become poorer. Class is an emerging factor in inequality alongside race. Seeking Sinatra's three-tier socio-economic structure. 1. Upper tier, professionals and management, racially mixed. 2. Middle tier, semi-professionals and working class, increasingly mixed. 3. Bottom tier, farm workers, domestic workers, unemployed, predominantly black. The need for substantive equality. Removing discriminatory laws alone is insufficient. Structural socio-economic disparities persist. Constitutional provisions for redress. S92, measures to advance those disadvantaged by past discrimination. Socio-economic rights, housing, healthcare, food, water, education, and social security. Land reform, addressing historical land dispossession, property clause. _ This section highlights the constitutional, historical, and social underpinnings of equality in South Africa, reinforcing substantive equality over mere formal equality. Rocket emoji. Next page. C. Formal and substantive equality. Formal equality requires the same treatment for individuals in similar circumstances, based on a neutral standard, ensuring that all are equal bearers of rights. Does not account for existing social and economic disparities. Substantive equality focuses on equality of outcomes, not just identical treatment. Examines real-world conditions and social contexts. Highlights the effects of laws rather than their mere form. Recognized as the constitutional standard for achieving true equality. Constitutional Court on Substantive Equality. Equality cannot be achieved by insisting on identical treatment. Each case must assess the impact of discrimination to determine if it furthers constitutional equality goals. Unfair discrimination may vary depending on the context. Restitutionary equality, S92. recognizes that past discrimination has ongoing consequences, ensures affirmative action and corrective measures to redress historic injustices. Equality delayed is equality denied. Failing to remedy past discrimination allows inequality to persist. Transformation and the Constitution. The Constitution is described as a transformative constitution. Transformation is a process towards an equal society, requiring temporary unequal treatment. Previously advantaged groups may experience disadvantages during this process. Transformation must be carried out in accordance with the Constitution. This section underscores the constitutional preference for substantive equality and the need for remedial measures to dismantle historical inequality. Rocket emoji. Next. Page 9.2 Interpreting Section 9. A. Section 9 compared to Section 8 of the Interim Constitution. Similarities between S8, Interim Constitution, and S9, Final Constitution. Both grant equal protection and benefit of the law. Both include a right to non-discrimination. Both explicitly allow affirmative action, S8-3 versus S9-2, with minor wording changes. Restitution of land rights, previously in S8-3b, was moved to S25-7 under the Property Clause. Key differences. 1. Expanded list of discrimination grounds, S9-3 adds pregnancy, marital status, and birth to the prohibited grounds. 2. Horizontal application, S9-4 extends non-discrimination rights to private individuals, unlike the Interim Constitution, which applied them only against the state. B. The stages of inquiry. Overview of S9. 1. S9-1, Equality before the law, equal protection and benefit. 2. S9-2, Affirmative action as a valid equality measure. 3. S9-3, Prohibition of unfair discrimination by the state on listed and analogous grounds. 4. S9-4, extends the prohibition of unfair discrimination to private persons. 5. S9-5, Presumption of unfairness for discrimination on listed grounds. Harkson v. Lane No. 3-stage test for equality clause violations. 1. Does the law differentiate between people or groups? If no, there is no S9 violation. If yes, does the differentiation have a rational connection to a legitimate government purpose? If no rational connection, S9-1 is violated. 2. Does the differentiation amount to unfair discrimination? Step 1. Is it discrimination? If on a listed ground, for example, race, gender, etc., discrimination is automatically established. If on an unlisted ground, it must impair human dignity or cause serious harm. Step 2. Is the discrimination unfair? If on a listed ground, unfairness is presumed. If on an unlisted ground, the complainant must prove unfairness. Focus: the impact of discrimination on the complainant and affected persons. If discrimination is not unfair, there is no S9-3 or 4 violation. 3. If unfair discrimination is found, can it be justified under the Limitations Clause, S36? Key principles from Constitutional Court decisions. Equality is a composite right. Harkson test is not rigid. National Coalition for Gay and Lesbian Equality v. Minister of Justice. Courts may skip the rational basis test if the discrimination is clearly unfair and unjustifiable. Types of differentiation. 1. Mere differentiation, S9-1, requires a rational connection to a legitimate government purpose. 2. Unfair discrimination, S9-3 and 4. Differentiation that violates human dignity and lacks justification. 3. Fair discrimination, differentiation that is justified and does not unfairly impact affected individuals. This section outlines the structured approach to equality claims under S9, emphasizing the importance of fairness and impact-based analysis. Next. Page. C. The relationship between Section 9 and Section 36. Section 36 is a general limitation clause. Applies to all rights in the Bill of Rights. Two-stage analysis. 1. Has the right been infringed? 2. Can the infringement be justified? Respondent must prove that the limitation meets the S36 criteria. Justification requires the law to be a law of general application, reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom. Challenges in applying S36 to S9, Equality Clause. Overlapping tests. S9 already assesses rationality and fairness, which are also key criteria in S36. Unfair discrimination, S9-3 and 4, is based on harm to dignity, It is difficult to justify such discrimination under S36. Irrational differentiation, S91, fails due to arbitrariness, making it unlikely to pass the S36 reasonableness test. Judicial approach. Harkson v. Lano requires courts to consider S36 even after finding an equality violation. However, no law violating S9 has ever been upheld under S36. Courts recognize the conceptual difficulty in justifying unfair discrimination or irrational differentiation under S36. This highlights that while S36 theoretically applies to S9, its practical significance is limited due to the self-contained fairness and rationality tests in S9. Next. Page 9.3 Mere differentiation. A. Differentiation and discrimination distinguished. Equality right does not prohibit classification. The state can differentiate between people if the differentiation is legitimate. Equality means treating similarly situated people the same, not treating everyone identically. Laws inherently classify and differentiate between people. Not all differentiation is unconstitutional. Courts only intervene if differentiation results in unfair discrimination. S93. If differentiation is not unfair discrimination, it is mere differentiation, assessed on rationality grounds. B. Rationality test. A law is unconstitutional under S91 if 1. It lacks a legitimate government purpose. 2. There is no rational connection between the differentiation and its purpose. Prinsloo v. van der Linde. State must act rationally, avoiding arbitrary laws or naked preferences. If a law lacks rational justification, it violates S91. Application in Prinsloo v. van der Linde. Facts. Forest Act 122 of 1984 required fire control measures in designated areas. Presumption of negligence applied to landowners in non-controlled areas, but not in fire control areas. Court's reasoning. Differentiation was not unfair discrimination, not based on S93 grounds. Rational connection. Presumption of negligence incentivized vigilance among landowners outside fire control areas, where no mandatory fire control measures applied. Conclusion. Differentiation was rationally related to the government's goal of preventing veld fires. Comparing the rationality test in other cases. SB and Tooley, failed rationality test, law, required prisoners without legal representation to obtain a judge's certificate before appealing. Court's ruling. Purpose, preventing courts from being overwhelmed, was legitimate. No rational connection. Law disadvantaged the most vulnerable group, unrepresented prisoners. Differentiation had no rational basis, as other prisoners could appeal without restrictions. Outcome, law violated S91 due to irrational differentiation. SB Renz, passed rationality test, law, required leave to appeal for those convicted in superior courts, while those convicted in lower courts had broader appeal rights. Court's ruling. Rational connection. Superior courts function differently from lower courts. Differentiation was logical given the different appeal processes. Outcome, law was rational and did not violate S91. Key takeaways. Mere differentiation is permissible if it is rationally related to a legitimate purpose. Unfair discrimination requires more scrutiny under S93. Courts will not assess alternative methods or efficacy, only whether the differentiation is rationally justified. Next. Page. Here are the study notes summarizing the provided text. Underscore. 9.3, Mere differentiation. A. Differentiation and discrimination distinguished. Equality does not mean identical treatment but requires those in the same moral position to be treated the same. Laws often differentiate between individuals for legitimate reasons. Differentiation is not automatically unconstitutional unless it amounts to unfair discrimination under S93 or an analogous ground. Differentiation that is not unfair discrimination is termed mere differentiation and is subject to a rationality test. B. Rationality. A law that differentiates between groups is valid if it does not violate S91 by denying equal protection or benefit under the law. A law violates S91 if it lacks a legitimate purpose. There is no rational connection between the differentiation and the purpose. Prinsloo v. van der Linde established that the state must regulate rationally. Arbitrary regulations or naked preferences are unconstitutional. A differentiation without a rational purpose violates S91. Application in Prinsloo. S84 of the Forest Act 122 of 1984 presumed negligence for landowners outside fire control areas but not inside. Differentiation was not unfair discrimination, not based on listed or analogous grounds. However, It was rational because it promoted fire prevention by increasing vigilance outside fire control areas. Rational connection test. Less strict than the test for limiting a right. Courts assess whether the government's purpose is legitimate and whether the differentiation is rationally related to that purpose. Courts do not evaluate alternative methods or effectiveness of differentiation. Example of law failing rationality test. SV and Tooley. Differentiated between prisoners with and without legal representation in criminal appeals. Purpose was legitimate, to prevent frivolous appeals, but the differentiation lacked rationality. Burden on represented prisoners, without justification. Contrast with SV Renz. Differentiation between appeals from superior and lower courts upheld. Rational because different court structures and procedures justify different rules. C. Section 9(1) in Rule of Law Rationality. General rationality requirement from the Rule of Law, S1, applies to all public power exercises. Any public power must be rationally linked to its purpose. Difference between S9(1) rationality and Rule of Law rationality. S9(1) rationality prevents arbitrary differentiation. Rule of Law rationality prevents arbitrary conduct in general, even without differentiation. If a law fails Rule of Law rationality, it also violates S9(1). D. Differentiation between provinces. Constitutional division of legislative power leads to different laws in different provinces. This differentiation is not necessarily irrational. Underscore. 9.4 Discrimination. A. Concepts of discrimination and unfair discrimination. Discrimination is differentiation on illegitimate grounds. S9(3) lists illegitimate grounds, for example, race, gender, sex. Analogous grounds are those with potential to impair dignity. Prinsloo, differentiation based on land location was not discrimination because it did not impact dignity. Discrimination must be unfair to be unconstitutional. Unfairness determined by impact on victims. Unfair discrimination treats people as inferior, incapable, or less deserving. Perpetuates or does not remedy disadvantage. B. Unfair impact. Constitutional Court considers 1. Complainant's societal position. Past discrimination? More likely to be unfair. 2. Purpose of the law/action. Legitimate goal? More likely to be fair. 3. Extent of rights impairment. Impact on dignity? More likely to be unfair. Factors assessed cumulatively, not a closed list. C. Presumption of unfair discrimination. S9(5) presumes discrimination on listed grounds is unfair. Burden shifts to respondent to prove fairness. For analogous grounds, the applicant must prove unfairness by showing an impact on dignity. Underscore. This summary provides structured, in-depth coverage of the content while maintaining brevity and clarity. Let me know if you need any modifications. Next. Page. Summary, Section 9(1) in Discrimination under Constitutional Law. 9.1 Section 9(1) in Rule of Law Rationality. General rationality requirement. All exercises of public power must be rational under the rule of law, S1 of the Constitution. Key principle: decisions must be rationally related to the purpose of the power exercised, otherwise, they are arbitrary and unconstitutional. Distinction from S9(1) rationality. S9(1) specifically addresses arbitrary differentiation rather than general arbitrariness. Rule of law rationality applies more broadly and does not require proof of differentiation. If a law/conduct is found irrational under the rule of law, it is automatically irrational under S9(1). 9.2 Differentiation between provinces. Legislative competence. The division between national and provincial governments can result in different legislative regimes across provinces. Not inherently irrational. Differences in laws between provinces do not automatically violate rationality requirements. Underscore. 9.3 Discrimination. A. Discrimination versus unfair discrimination. Definition: discrimination is differentiation on illegitimate grounds. S9(3) lists these. Analogous grounds: courts recognize additional grounds akin to those listed, based on characteristics that impair human dignity. Key principle: the Equality Clause prohibits unfair discrimination, not all discrimination. Unfair discrimination occurs when differential treatment impairs dignity or perpetuates disadvantage. B. Unfair impact test. Constitutional Court factors 1. Position of complainants. Disadvantaged groups are more likely to be unfairly affected. 2. Nature and purpose of discrimination. If it serves an important societal goal, it may not be unfair. 3. Extent of impairment, must assess whether dignity or rights have been significantly harmed. Objective and cumulative assessment, factors are not exhaustive and may evolve with jurisprudence. C. Presumption of unfair discrimination. Listed grounds, S95, presumed to be unfair unless proven otherwise. Analogous grounds, applicant must prove unfairness by showing an impairment of dignity. Burden of proof, respondent must prove that listed ground discrimination is fair. D. Fair discrimination. Not all discrimination is unfair. Example, President of the Republic of South Africa v. Hugo. President Mandela granted remission of sentence only to imprisoned mothers with children under 12. Court held this was discrimination based on sex and parenthood, a listed ground. However, the discrimination was not unfair since it benefited children and historically disadvantaged women. E. Unfair discrimination. Definition, imposes burdens on historically disadvantaged groups or impairs dignity. Test, if it serves a worthy societal goal, it may be fair. Example, City Council of Pretoria v. Walker. Flat rate charges in townships were not unfair discrimination. Townships lacked metering equipment. Temporary measure pending meter installation. No impairment of dignity. Selective debt recovery was unfair discrimination. Legal action was only taken against white residents. No justified societal goal. Racially discriminatory without a valid rationale. Underscore. Key takeaways. General rule, all public power must be rational. Differentiation does not equal discrimination. Some differences in treatment are legally justified. Discrimination only violates the Constitution if unfair. Fairness test, focuses on dignity, societal purpose, and historical disadvantage. Court's approach, evaluates discrimination on a case-by-case basis using a cumulative test. Next page. Fair and unfair discrimination. D. Fair discrimination. Not all discrimination is unfair. Some forms of discrimination may be justified. Example, President of the Republic of South Africa v. Hugo, 1997, President Mandela granted sentence remission to mothers with children under 12 but not to fathers. Court found discrimination on sex and parenthood of children under 12, a listed ground. However, the discrimination was not unfair. Based on generalization that mothers bear primary child-rearing responsibilities, benefited children and alleviated burdens on women, denied early release to fathers but did not impair dignity or create historical disadvantage, aimed at an important societal goal, assisting vulnerable groups, disabled, youth, and mothers. E. Unfair discrimination. Occurs when discrimination has an unfair impact, particularly on historically disadvantaged groups or when it impairs dignity. City Council of Pretoria v. Walker, 1998, Two policies of the Pretoria City Council. 1. Flat rate system for townships, Atteridgeville and Mamelodi, versus metered tariffs in Old Pretoria. Not unfair discrimination. Townships lacked meters, Old Pretoria was wealthier and had them. Interim solution while meters were installed, no significant harm to residents of Old Pretoria. 2. Selective debt recovery, legal action against residents of Old Pretoria only, unfair discrimination. No legitimate justification for not enforcing payments in townships. Policy was not linked to financial ability and disproportionately impacted white residents of Old Pretoria. Court found it to be unfair racial discrimination. F. The listed grounds of discrimination, Section 9.3, presumption of unfairness if differentiation is based on a listed ground. Intersectionality. Claims may involve multiple listed grounds, for example, race and gender discrimination affecting black women differently from white women or black men. I. Race, color, ethnic origin. Apartheid-era racial discrimination necessitates positive measures to remedy historical injustices. International Convention on the Elimination of Racial Discrimination prohibits discrimination based on race, color, descent, or national/ethnic origin. 2. Gender, sex, pregnancy. Sex versus gender. Sex equals biological differences. Gender equals social roles and expectations. Examples of discrimination. Sex-based, discrimination against pregnant women. Gender-based, stereotypes about women's workplace abilities or parental roles. Just as sex, gender discrimination is more deeply embedded and harder to expose than racial discrimination. 3. Sexual orientation. Bold inclusion of sexual orientation in the Bill of Rights. AA. Decriminalization of homosexuality. National Coalition for Gay and Lesbian Equality v. Minister of Justice, 1998, Sodomy laws declared unconstitutional as they reinforced prejudice and encouraged discrimination. Defined sexual orientation broadly to include bisexual and transsexual individuals. Laws criminalizing same-sex acts encouraged blackmail, police entrapment, and violence, for example, queer bashing. BB, discrimination and legal benefits. National Coalition for Gay and Lesbian Equality v. Minister of Home Affairs, 1999, Aliens Control Act, 1991. Discriminated against same-sex partners by excluding them from immigration benefits granted to married spouses. Court-held exclusion reinforced harmful stereotypes that same-sex relationships lack family characteristics like love, support, and companionship. That procreation is essential to family life, which is demeaning to childless couples, both same-sex and heterosexual. Found to be irrational and unjustifiable. Subsequent cases striking down same-sex discrimination. Dutoit v. Minister of Welfare and Population Development, same-sex couples allowed to jointly adopt children. Sechwell v. President of South Africa, same-sex partners of judges granted survivor benefits. JV Director General, Department of Home Affairs, same-sex parents recognized on birth certificates. Gorey v. Culver, same-sex partners included in intestate succession rights. Conclusion. Discrimination is not inherently unfair. Context and impact determine fairness. Courts distinguish between differentiation with legitimate purpose and unfair discrimination that entrenches historical disadvantage or violates dignity. South African jurisprudence has actively addressed discrimination in race, gender, and sexual orientation, reinforcing substantive equality. Next page. Exclusion of persons in same-sex relationships from marriage. Denying marriage to same-sex couples constitutes unfair discrimination based on sexual orientation. Common law definition of marriage as a heterosexual union was challenged in Forey v. Minister of Home Affairs. Medalage, while marriage is a choice, only heterosexuals had the option to marry. Excluding same-sex couples denies them legal/social recognition, privileges, and obligations. Sends a harmful message of inferiority to LGBTQ+ individuals. The Supreme Court of Appeal ruled that the definition of marriage must be changed. Constitutional Court upheld the ruling. International law does not privilege one form of family. Religious objections were rejected. S. 15(3) of the Constitution. Religious doctrine cannot dictate constitutional interpretation. The law must accommodate different worldviews fairly. Marriage Act did not compel religious ministers to solemnize marriages against their beliefs. Common law definition of marriage in S. 30 of the Marriage Act declared unconstitutional. Declaration of invalidity suspended for 12 months to allow legislative reform. Civil Union Act 17 of 2006 enacted. Provides for civil unions for same-sex and heterosexual couples. Parties choose between marriage or civil partnership. Rights and benefits identical to those under the Marriage Act. Marriage Act remains available only to heterosexual couples. Marital status. Prohibits historical privileging of common law marriage over other forms. Prevents unfair burdens on married persons not imposed on unmarried individuals. Robinson v. Volks No. High Court ruled that Maintenance of Surviving Spouses Act 27 of 1990 unfairly discriminated against unmarried life partners. Remedy, permanent life partnership read into definitions. Constitutional Court reversed the ruling. Act does not unfairly discriminate. Marriage holds a special legal and social status. Marriage triggers specific rights and obligations by law. Distinction between married and unmarried persons justified. Maintenance duty arises only in marriage, not for cohabitants. Volk's ruling excluded consideration of same-sex and polygynous relationships. With the Civil Union Act, same-sex couples can marry, so exclusion from marriage benefits is now a personal choice. Volk's does not prevent the extension of common law claims, for example, breadwinner's action, to unmarried life partners. Recognition of Customary Marriages Act recognizes polygamous customary marriages but lacks specific customary law requirements. Ngunyama v. Milane. Second marriage unregistered, High Court ruled it invalid. SCA overturned, all marriages must have equal status. Age. Different from other grounds, age changes throughout life. Age-based rules apply universally at different life stages, for example, voting, driving, marriage. Common legal challenge, compulsory retirement. Age concern England v. Secretary of State for Business, Enterprise and Regulatory Reform. UK law set compulsory retirement at 65. Challenged as EU law prohibits age discrimination. European Court of Justice. States may justify age-based differentiation if it serves legitimate aims, For example, employment policy left national courts to assess specific rules. Next page. Exclusion of persons in same-sex relationships from marriage. To provide marriage benefits only to heterosexual couples is unfair discrimination based on sexual orientation. Common law historically confined marriage to heterosexual couples. Forey v. Minister of Home Affairs, SCA case, challenged the definition of marriage. Medalla J. Only heterosexuals were given the choice to marry, denying homosexuals the legal, social, and economic recognition associated with marriage. CC ruling. Denial of marriage rights sends a message of inferiority to same-sex couples. International law does not privilege one form of family over another. Religious doctrine cannot be used to interpret the Constitution, S. 15.3. The Marriage Act did not compel religious ministers to solemnize marriages inconsistent with their beliefs. The common law definition of marriage and S. 30 of the Marriage Act were declared unconstitutional. Civil Union Act 17 of 2006. Allows same-sex and heterosexual couples to enter into civil unions or marriages. Civil unions confer the same legal consequences as marriages under the Marriage Act. The Marriage Act remains available only to heterosexual couples. Marital status. Protects against historical privileging of common law marriage over other forms. Prevents unjust burdens imposed on married persons but not on unmarried persons. Robinson v. Volksno, H.C. case. The Maintenance of Surviving Spouses Act 27 of 1990 unfairly discriminated against permanent life partners. H.C. ruling, unfair discrimination, remedy was to include permanent life partnerships in the Act. CC overturned H.C. decision. Granting maintenance benefits to married people only is not unfair discrimination. Marriage has a special legal status justifying legal privileges. Unmarried partners do not have a reciprocal duty of support by operation of law. The Volks ruling does not address same-sex couples or polygynous relationships. Breadwinners or dependents action can still be developed at common law to cover permanent partnerships. Customary marriages. Recognition of Customary Marriages Act recognizes polygamous marriages. Nguyen v. Milane, SCA case. HC invalidated a second unregistered customary marriage. SCA, this breached equal status rights in marriage. Age discrimination. Unlike other grounds, age changes throughout life. Everyone is subject to age-based laws, for example, voting, drinking. Comparative law. Age concern England case, ECJ. UK's mandatory retirement age of 65 challenged under EU law. ECJ upheld it, allowing age-based laws if objectively justified by legitimate aims. Disability discrimination. Under litigated ground, Singh v. Minister of Justice, HC case. Partially cited magistrate denied promotion for lacking a driver's license. Court ruling. Discrimination was not based on disability. However, government failed to promote disabled persons as per constitutional duty. Ordered reconsideration of her application with due weight to her disability. Reasonable accommodation principle. Disability discrimination is not just negative, it requires positive action. Inaction can itself constitute unfair discrimination. Religion, conscience, belief, culture, and language. Distinct from freedom of religion, S15, and minority rights, SS 30-31. Discrimination inquiry overlaps with rights analysis but includes an unfairness test. Birth and social origin discrimination. Illegitimacy, children born to unmarried parents, historically led to discrimination. Covered under birth in S93. Any differentiation based on parental marital status is presumed unfair. Social origin includes class, clan, or family membership. Defamation and protected characteristics. Defamation equals statements lowering reputation in right-thinking society. LaRue v. Day. It is not defamatory to depict someone as gay, even if false. Allowing such claims would reinforce unconstitutional discrimination. Next page. Study notes, Unfair discrimination in South African law. By disability. Disability is an under-litigated ground of discrimination. Singh v. Minister of Justice and Constitutional Development. High Court, Equality Court, case. Applicant, a partially cited magistrate, denied promotion due to lack of a driver's license. Claim, government failed to prefer people with disabilities as required by the Constitution. Court held she was not excluded because of her disability but noted the appointment committees failed to consider their duty to advance disabled people. Interpretation of S93. Government has a duty to promote the position of disabled people. Government order to reconsider applications while considering disability. Reasonable accommodation principle. Disabled people require positive action to remove barriers to economic participation. Discrimination includes failure to take positive steps for reasonable accommodation. Doing nothing can amount to unfair discrimination. 7. Religion, conscience, belief, culture, and language. Separate from SS 30 and 31 rights but may overlap. Courts assess whether discrimination is unfair in addition to determining whether a person's religious or cultural practices were interfered with. 8. Birth and social origin. Illegitimacy, children born out of wedlock, is covered under birth in S93. Any differentiation based on parents' marital status is presumed unfair. Social origin includes class, clan, or family membership. G. Defamation and discrimination. Defamation, statement lowers a person's esteem among right-thinking members of society. LaRue v. Day. Depicting someone as having a characteristic in the listed grounds, for example, being gay, cannot be defamatory. To hold otherwise would enforce irrelevant categories of differentiation. H. Analogous grounds. Unfair discrimination, differentiation based on illegitimate grounds. Analogous grounds, not listed in S93 but impact human dignity similarly. No presumption of unfairness. Applicant must prove impairment of dignity or serious harm. Factors to determine unfair impact. 1. Complainant's position in society and past discrimination. 2. Purpose of the law or action, does it serve a legitimate societal goal? 3. Degree of impairment to complainant's dignity and rights. Case law. Lerbiot M.V. Mech for education. Regulation preventing non-citizens from permanent teaching posts was unfair discrimination. Citizenship is an analogous ground since it affects dignity and creates vulnerability. Hoffman v. South African Airways. HIV-positive individuals denied employment as cabin attendants. Court avoided classifying HIV as a disability but ruled HIV status was an analogous ground. Discrimination based on prejudice, violating dignity. I. Direct and indirect discrimination. Direct discrimination expressly differentiates based on a prohibited ground. Indirect discrimination. Law appears neutral but has discriminatory effects. Griggs v. Duke Power Company, U.S. case. High school diploma requirement disproportionately excluded black employees. City Council of Pretoria v. Walker. Different utility tariffs and debt collection policies between Pretoria suburbs and townships effectively discriminated against white residents. Racially neutral policies can be discriminatory due to apartheid's geographic racial link. Proving indirect discrimination requires evidence showing discriminatory effect or administration. Democratic Party v. Minister of Home Affairs. Barcoded ID requirement for voting alleged to be indirectly discriminatory. Court found insufficient evidence to prove a discriminatory effect. S. v. Jordan. Challenge against criminalization of prostitution as indirect gender discrimination. Majority, neutral provision distinguishing dealer, prostitute, and customer. Minority, reinforces harmful gender stereotypes, women as fallen, men as weak. Law criminalizes women directly while men face only indirect liability as accomplices. These notes summarize key cases and principles concerning unfair discrimination under South African constitutional law, particularly focusing on disability, analogous grounds, and direct versus indirect discrimination. Next. Page. J. Discrimination need not be intentional. Applicants do not need to prove intent to establish unfair discrimination. Proof requirement, show unfair discriminatory effect, not intent. Reason. Requiring proof of intent would impose an unreasonable burden, especially in indirect discrimination cases. However, intent is relevant when assessing unfairness. If discrimination was unintentional and aimed at a legitimate societal goal, it may be less likely to be considered unfair. If the action intended to discriminate, it is more likely to be unfair. Next. Page. 9.5 Affirmative action. Definition: preferential treatment for disadvantaged groups, for example, race, gender, to rectify historical inequalities. 2 perspectives. Exception to equality: reverse discrimination favoring past victims while discriminating against previously advantaged groups. Part of equality: constitutional view, a means to achieve substantive equality by addressing systemic inequalities. Constitutional framework, Section 9(2). Equality includes full and equal enjoyment of all rights and freedoms. The state has a positive duty to promote equality. Affirmative action is not a derogation from equality but a means to achieve it. Requirements for affirmative action measures. S92 For a measure to be a valid affirmative action program, it must 1. Target persons or groups disadvantaged by unfair discrimination. 2. Be designed to protect or advance such persons. 3. Promote the achievement of equality. If these criteria are met, the measure is not unfair discrimination, even if differentiation is based on a listed ground, for example, race, gender. Ad hoc decisions do not qualify. The program must be structured and systematic. Justification of affirmative action. Justified by long-term societal benefits, for example, redressing past inequalities, must have a reasonable likelihood of achieving its goal, not necessarily a strict necessity. Courts do not require proof of no less onerous alternative. Key case law. Mutalabi University of Natal. Indian student denied medical school admission due to a quota favoring African students. Court upheld the policy, reasoning that Africans face greater disadvantage than Indians. Criticism. Court failed to ensure the program was rationally and carefully constructed to achieve equality. Public Servants Association v. Minister of Justice. Affirmative action must have a rational connection between means and ends. Minister of Finance v. Van Heerden. Overruled previous interpretation requiring a necessity standard. Affirmative action only requires a reasonable likelihood of achieving equality, not a strict causal link. South African Police Service v. Solidarity Obo Barnard. White policewoman denied promotion due to overrepresentation of whites. Court upheld decision as a rational corrective measure under S92. Criticism. The post was left unfilled, undermining transformation efforts. Next. Page 9.6. The Promotion of Equality and Prevention of Unfair Discrimination Act. Overview. Section 9(4) of the Constitution mandates national legislation to prohibit/prevent unfair discrimination, particularly private discrimination, conduct-based discrimination by individuals or institutions. Item 23(1) of Schedule 6 required enactment by February 3, 2000. The Promotion of Equality and Prevention of Unfair Discrimination Act 4 of 2000, Equality Act, was enacted in response, with parts effective from September 1, 2000 and the rest from June 16, 2003. Objectives of the Equality Act. Aims to eradicate social and economic inequalities from colonialism, apartheid, and patriarchy. Achieves its goals by 1. Prohibiting unfair discrimination by the state and private persons. 2. Providing remedies for victims of unfair discrimination. 3. Promoting substantive equality. Principle of subsidiarity. Claims of equality violations must be pursued under the Equality Act, not directly under Section 9 of the Constitution, unless the Act itself is being challenged. Other legislation/conduct beyond the Act is involved. Criticism and interpretation. The Act is criticized for lack of clarity and coherence. Courts must interpret it in line with constitutional protections, ensuring it does not reduce constitutional rights or infringe other rights. Constitutional jurisprudence on Section 9 will remain influential in interpretation. A. Prevention of unfair discrimination. Horizontal application binds both the state and private persons. Exclusion. Workplace discrimination is governed by the Employment Equity Act 55 of 1998. General prohibition on unfair discrimination aligns with Section 9 of the Constitution. Advantages of the Equality Act over Section 9 challenges. 1. Burden of proof shifted. Once a complainant establishes a prima facie case of discrimination, the respondent bears the full burden to prove no discrimination occurred, or differentiation was not based on a prohibited ground. 2. Presumption of unfairness. Discrimination on prohibited or analogous grounds is presumed unfair. Complainant must show systemic disadvantage, undermining of human dignity, serious adverse impact on rights. Unlike Section 9(5) of the Constitution, the respondent always bears the burden of proving fairness. 3. Specified instances of unfair discrimination. The Act lists clear examples of unfair discrimination based on race, gender, and disability, preventing arguments that such practices are not discriminatory, for example, exclusion of women from inheritance, female genital mutilation. 4. Prohibition of hate speech and harassment. Hate speech, harassment, and discriminatory dissemination of information are separately outlawed. Unlike unfair discrimination, these acts are automatically prohibited without requiring proof of unfairness. Hate speech prohibition is broader than Section 16(2) of the Constitution and must be justified under the Limitations Clause. B. Access to justice. Equality courts. Magistrates and high courts serve as equality courts within their jurisdictions. Specially designated magistrates/judges and clerks handle cases. Cases cannot proceed until a presiding officer is designated. Standing to sue. Broad categories of persons can enforce the Act, aligning with Section 38 of the Constitution. Equality Court may refer cases to more appropriate forums. Remedies. Equality courts have wide-ranging enforcement powers, including interdicts and damages awards, unconditional apologies, policy audits and progress reporting. No criminal offenses are created, but courts may refer cases to the Director of Public Prosecutions for criminal charges, for example, crimen injuria, indecent assault and harassment cases. C. Promotion of equality. State obligations must develop substantive equality through action plans, codes of practice, information campaigns, private sector obligations. Those contracting with the state or exercising public power must comply with equality duties. Companies, partnerships, clubs, and associations may be required to develop equality plans, follow prescribed codes of practice, report on equality measures, annex lists of discriminatory practices, cover labor, education, healthcare, housing, insurance, property, sports, and services. Examples include redlining in banking and refusal of club membership on discriminatory grounds. Reinforces that private conduct in these areas is subject to anti-discrimination principles. Conclusion. The Equality Act operationalizes Section 9 of the Constitution, providing stronger procedural protections and clearer remedies than direct constitutional litigation. Procedural benefits include burden shifting, presumed unfairness, and broad remedies. Key challenges include ambiguity in certain provisions and balancing constitutional rights. Equality jurisprudence will remain crucial in interpreting and applying the Act. Next. Chapter 10 Human Dignity 10.1 The centrality of human dignity in the Constitution 10.2 Dignity and punishment. A. Cruel, inhuman and degrading treatment or punishment. B. Imprisonment 10.3 Actio Injuriarum 10.4 Marriage and family life. Page. Chapter 10 Human Dignity 10.1 The centrality of human dignity in the Constitution. Human dignity is a foundational value in the Constitution, alongside equality and freedom. It is recognized as an independent right under S10, which guarantees that everyone has inherent dignity and the right to have their dignity respected and protected. The Constitutional Court has emphasized dignity's foundational role in interpreting rights and determining the limits of state power. Dignity is linked to other rights, for example, equality, freedom, and socioeconomic rights. Courts use human dignity to develop jurisprudence on unfair discrimination, access to socioeconomic rights, and limitations on punishment. 10.2 Dignity and punishment. A. Cruel, inhuman and degrading treatment or punishment. Section 12(1)(e) prohibits cruel, inhuman or degrading treatment or punishment. The Constitutional Court has ruled that corporal punishment, both judicial and in schools, violates human dignity. S. V. Williams 1995. The death penalty was declared unconstitutional in S. V. McQuanian, 1995, due to its violation of dignity, as it treats individuals as objects rather than autonomous beings. B. Imprisonment. Although imprisonment is a lawful punishment, it must comply with dignity principles. Detainees retain basic human rights, except where limitations are justifiable under S36. Overcrowding, poor conditions, and excessive sentences may constitute degrading treatment. 10.3 Actio Injuriarum. A common law remedy protecting personality rights, including dignity, reputation, and privacy. The plaintiff must prove that the defendant intentionally impaired their dignity. Examples include defamation, wrongful arrest, and public humiliation. Courts balance this remedy with freedom of expression, particularly in cases of public interest. 10.4 Marriage and family life. Marriage and family are protected under S15, freedom of religion, S30, language and culture, and S31, cultural and religious communities. Courts have ruled that family life and marriage decisions must respect human dignity, for example, protection from forced marriages, gender-based discrimination. Recognition of same-sex marriages in Minister of Home Affairs v. Forey, 2005, was grounded in dignity and equality principles. Next. 10. Human dignity. Everyone has inherent dignity and the right to have their dignity respected and protected. Page. Chapter 10, Human Dignity. Human dignity is a fundamental right under S10 of the Constitution, stating that everyone has inherent dignity and the right to have their dignity respected and protected. It is one of the core constitutional values, alongside equality and freedom. Courts interpret human dignity as both a substantive right and a guiding principle in balancing competing rights and interests. It plays a crucial role in anti-discrimination law, criminal justice, socioeconomic rights, and personal autonomy. Violations of dignity can arise in punishment, imprisonment, personal injury law, actio injuriarum, and family law matters. Next. Page 10.1 The centrality of human dignity in the Constitution. Human dignity is a foundational value in South Africa's constitutional framework, recognized in S1 alongside equality and human rights. It is part of an objective, normative value system, shaping legal interpretation and state obligations. Post-war constitutionalism influenced South Africa's approach, distinguishing it from the U.S. model, which prioritizes individual liberty. The Constitutional Court acknowledges dignity as a guiding principle in interpreting all constitutional rights, a basis for socio-economic rights, housing, healthcare, food, water, social assistance, a counterbalance in policy decisions where individual rights and societal interests must be weighed. Meaning and legal interpretation of human dignity. The Constitutional Court has not provided a precise definition but recognizes dignity as derived from Kantian moral philosophy. Each person has intrinsic worth. The foundation of freedom and bodily integrity, including protection against slavery and physical harm. Closely linked to equality, as all individuals possess dignity equally. Dignity is a constitutional right. Recognized in the Bill of Rights, S10, interconnected with other fundamental rights, including the right to life. Considered by the Constitutional Court as one of the most important rights. Jurisprudence on human dignity. National Coalition for Gay and Lesbian Equality v. Minister of Justice, 1998, the court struck down the criminalization of sodomy as violating dignity. Held that punishing homosexual conduct degrades and devalues individuals, violating S10, dignity and political rights. Democratic participation is linked to dignity, as voting is a badge of dignity and personhood. Universal suffrage affirms individual worth and equal participation in governance. Dignity in constitutional interpretation and limitations analysis. Dignity serves multiple roles. A justiciable right that can be enforced. A constitutional value influencing interpretation of other rights. A factor in limitations analysis, balancing rights under S36. Subsidiarity principle. Specific rights that embody aspects of dignity, for example, right to equality, privacy, should be applied first before relying on S10. The general right to dignity is only invoked when no other right applies. This section establishes dignity as central to South Africa's legal order, influencing rights protection, governance, and legal interpretation. Next. Page 10.2 Dignity and punishment. A. Cruel, inhuman, and degrading treatment or punishment. S. V. Williams, 1995. Punishment must respect human dignity. Degrading or dehumanizing treatment is unconstitutional. The state is responsible for upholding dignity, even when punishing criminals. Even the worst offenders retain their dignity and must not be subjected to brutal treatment. S. V. McQuanian, 1995. The death penalty violates human dignity and constitutes cruel, inhuman, and degrading punishment. Dignity is a key factor in determining whether a punishment is unconstitutional. S. V. Williams, 1995, Long J. The prohibition of cruel punishment is based on the dignity of man and societal concepts of decency. While dignity covers more than just protection from cruel punishment, such treatment is a clear violation of dignity. Section 12(1)(e), right not to be subjected to cruel, inhuman, or degrading punishment, is further elaborated in Chapter 12. B. Imprisonment. S. V. McQuanian, 1995, Chaskalson P. Imprisonment impairs dignity but is a justifiable punishment under the criminal justice system. Prisoners retain constitutional rights, subject only to justifiable limitations under the prison system. Any restriction on prisoners' rights must be justified in terms of crime prevention and rehabilitation. Life imprisonment and human dignity. The Constitutional Court has not ruled on life imprisonment but suggested it as an alternative to the death penalty. Ackermann J. referred to the German Constitutional Court's decision on life imprisonment. The state can incarcerate dangerous criminals for life to protect society. However, Dignity requires that prisoners have some hope of release if they demonstrate rehabilitation. South African courts are likely to follow this approach. Life imprisonment is permissible but must allow for parole in exceptional cases. A sentence grossly disproportionate to the crime would violate S12(1)(e and the right to dignity. Svtkib, Namibia, 1996. Life imprisonment is constitutional but may be unconstitutional if grossly disproportionate to the crime. A life sentence without parole may constitute cruel, inhuman, or degrading punishment. This section establishes that punishment must respect dignity, with imprisonment and life sentences requiring safeguards against disproportionate severity. Next. Page 10.3 Actio injuriarum. Common law remedy for injury to person, dignity, or reputation. Claimant must prove conduct was both subjectively and objectively insulting. Dignity in the Constitution has a broader meaning than in common law. Dignity versus reputation. Dignity concerns an individual's self-respect. Reputation concerns others' respect for the individual. Defamation versus dignity. A violation of dignity under Actio injuriarum does not make a defendant additionally liable for defamation. Defamation and freedom of speech. The common law action for defamation historically undervalued freedom of speech. The Constitution requires a balance between free speech and dignity, discussed in Chapter 16. 10.4 Marriage and Family Life. Dawood v. Minister of Home Affairs, Van Herden J. The right to dignity protects marriage and family life. Includes the core right and duty of spouses to live together. Excessive immigration permit fees, over R10,000, violated this right by forcing poor families to separate. The fee was not justified, as there were less restrictive alternatives, for example, interviews to verify marriages. Constitutional Court, Oregon J., confirmed this approach. Right to marry and raise a family is protected under the Constitution. Marriage is central to personal fulfillment. Any legislation preventing or restricting it violates dignity. Impairment of cohabitation rights also constitutes an infringement of dignity. Invalidation of S25(9)(b) of the Aliens Control Act 96 of 1991. Law required foreign spouses to have a valid temporary residence permit before applying for permanent residence. Left foreign spouses at the mercy of immigration officials without proper legal guidance. Boyson v. Minister of Home Affairs. Applied Dawood ruling. Held that requiring foreign spouses to apply for work permits outside South Africa was unconstitutional, as it violated dignity. This section establishes that marriage and family life are protected under dignity rights, and immigration laws must not unduly separate families.